Prior to the advent of insolvency and bankruptcy code, I was working in entry strategy into India, primarily advising the Japanese companies to set up their base in India. And I started practicing in this IBC field from June 2017. So it has been almost now more than 9 years since I've been working in this field. And I have been granted, I'm thankful to ICSI IIP for granting me an opportunity to present this, to address this gathering on this topic of conducting the practical aspects of conducting the COC and other meetings. I'll just share my PPT, a short PPT that I have prepared for this session. So in this PPT, what I have done, whatever the regulations I have covered, those would be IBBI latest CRP regulation amended up to 9th June 2026 and couple of liquidation regulation amended up to 2nd June 2026. So latest one, what would be now, given the audience involved, what my attempt would be that we are all senior company secretaries, chartered accountant or professionals and IPs. So we not need to dwell in the theory too much. I will try to keep the presentation as far as practical possible and share some of my personal experiences, what I have faced as an advocate or counsels for the RP or working as an RP. And I will, at the end of presentation, I will also discuss two NCLAT judgment, which will touch upon the practical aspect that what happens during a COC meeting and how far-reaching impact that can have on the outcome of a particular CIRP, or for that matter, on how the conduct of the RPs. So regulations, the regulation will provide legal framework, but our focus would be on practical conduct of meeting, drafting of agenda and minutes, handling difficult stakeholders. I'll cover some points that which I have seen, I have faced. So someone has consulted with me on the issues faced during the COC meeting. Common mistakes by RP's liquidator. I have even prepared a short slide on few of the IBBI orders, disciplinary orders, which are, which have to taken place because of the some conduct or lack of conduct in the COC meeting. Right. So first regulation 17 of CIRP regulation, we are all aware. It is regarding constitution and first meeting of committee of creditors. The IRP shall file the report certifying constitution of COC to adjudicating authority within 2 days of verification of claim. The first meeting of the committee of creditors shall be held within 7 days of the filing of the report. We are all aware of this theoretical provision. What is the practical significance of the first COC? That is, a well-conducted first COC meeting sets the tone for the entire CIRP. I will try to cover two things in this slide. So regulations are there on the screen. I need not to discuss these regulations again and again. We are all aware of it. 2-3 aspects that I would like to cover, which are the recent amendments in the CIRP regulation. One is, so first COC meeting, general agenda that we cover are like taking note of the admission order, public announcement, claims received, constitution and voting right, taking note of the step taken by the RP. One thing which stands out here is that we need to pass a resolution for opening of a CIRP bank account. This is important because this is regulation governed. For every CIRP, and in the case of real estate, project-wise CIRP, for every project, a separate bank account has to be operated. So it is better that we take an approval for opening of a separate CIRP account. There are few new regulations which were also introduced. One was regulation 13B. Let me do one thing. I'll open the text of that regulation for better understanding. Yes. So the title of this regulation 11, if we see the amendment 114, it was introduced in 8th June 2026. It is very important for us to pay attention to. though the title is approval of committee for insolvency resolution process cost, the main crux of this regulation is the RP shall prepare a going concern assessment report which shall include estimated income, expenditure, cash flow arising from continuation operation, details of working capital requirement, material risk of value erosion arising from continuation or suspension of operations. The now main part is this. The resolution professional shall place the going concern assessment report prepared under Regulation 2 at the first meeting of the committee. So, although under the regulation there are very few examples of mandatory agenda that are to be kept before the first COC meeting, this is one of them where the statute or the regulation specifically provide that what is to be presented by the IRP before the committee in the first meeting. Now, if it's a real estate CIRP, I'll give another example that emanates from the recent discussion paper floated by the IBBI on the real estate. In the if it's a real estate CIRP, the most of our time qua first COC meeting goes into verification of the claim if it is 300, 400, 500 allottees claim and proper constitution of COC. But now, if we are to prepare or put before this COC, this going concern report, so it becomes a big task for all the IPs. So we need to take care of this regulation. It has been recently introduced on 8 June 2026. My understanding of this regulation would be that it will not be have a retrospective effect on the ongoing CIRP. These will be applicable for any CIRP that will start after 8 June 2026. Another thing for this slide, that common first meeting agenda item that I would like to cover is this is the recent discussion paper which has been floated by IBBI, qua real estate insolvency. Now, so there are several things which have been now, they are trying to introduce to strengthen the outcome in the real estate CIRP, and they have invited suggestions. What is Yes. So what is relevant for our today's discussion is, I will read it out. The committee recommended that insolvency proceeding in real estate sector should ordinarily be conducted on a project-wise basis, recognizing each real estate project as a distinct economic unit. The committee was of the view that insolvency proceeding may be confined to the defaulting project, allowing solvent or unrelated project of the same developer to continue operating under existing arrangement. The committee further recommended completed or substantially completed or occupied project should ordinarily remain outside the scope of insolvency proceedings except in exceptional circumstances. Proposed solution. It is proposed that, again, the point which we have to note and we have to pay our attention is, it is proposed that in first meeting of the COC, in its first meeting, the COC may undertake a project-wise assessment of all real estate project of the CD. For this purpose, the resolution professional RP shall identify and present before the COC details of all projects of the CD, including their RERA registration particulars, stage of completion, occupancy status, status of possession, and such other information as may be relevant. So this is always very, very dangerous language of the law, such other information as may be relevant, because we never know what it will cover. Now, draft amendment. Let us read it. It is proposed to insert Regulation 18 capital B after the existing Regulation 18 as under 18B, identification and exclusion of real estate project. Before I read it, it says after existing Regulation 18. Let us see what is the existing Regulation 18. Sometimes it is advantageous to appreciate the amendment. So current Regulation 18 is meeting of committee. So they are proposing to introduce a Regulation 18B just after this Regulation 18. And what does it say? Where the corporate debtor has more than one real estate project, the resolution professional shall place before the committee in its first meeting project-wise details of all real estate projects of the corporate debtor, including RERA registration. This is easy. RERA registration, if they have registered their project on the website of RERA, we can always get this detail. What is tricky? tricky part is stage of completion of each real estate project, status of possession and occupancy in each real estate project, number of completed and incomplete units in real estate project. Now I ask this gathering, some are the senior IBs also who must have entered real estate project. Are we able to gather this information B, C, and D? Forget about in first 30 days when we have to convene the first COC meeting. Are we able to gather this information even at the time of preparation of information memorandum or resolution plan? Anybody, please, who has done a real estate CIRP, whether they agree with me or not. Anup ji? Anup sir?
That it should be included. Yes, sir. I think that it should be included.
This should be
Included all three aspects.
it should be included. But my question to myself and to everybody is that for, let's say, a company has a 2 or 3 real estate project without proper cooperation from the suspended director, how come RP is going to have this level of information available with him to present in first 30 days of CIRP before the first COC meeting? So see, I'm not criticizing or I'm not supporting this regulation, because the topic is that effective conduct of COC meeting and slide is first COC meeting. So I'm just bringing it to the knowledge of the gathering that this kind of amendment is coming. And if it's a real estate project and there are multiple, for a corporate debtor, if there are multiple projects in that company, then this information will be required to be gathered. Unless, of course, if this amendment does not take place. If it does take place, then this becomes very tricky for the real estate project CIRP. Another regulation which I would like to draw the attention of the gathering is, which has been again recently introduced, is Regulation 16 capital E. Now, what does this say? Assistance to committee where creditors other than scheduled banks or public financial institution hold significant voting share, where creditors other than a scheduled bank or a public financial institution as defined in clause 72 of section 2 of the Companies Act hold more than 66% of the voting share in the committee, the RP shall invite the 5 largest unrelated operational creditor, which shall include the 3 largest authorities to whom statutory dues are owed by value of admitted claims, to attend the meetings of the committee as observers with no voting rights, and record their observations, if any, in the minutes of the meeting of the committee. So how come this regulation becomes relevant for the first COC meeting? It becomes relevant that when we are before calling the first COC meeting, we have to constitute the COC. And when we are doing the verification and admission of the claim and doing the constitution of COC and filing the report, we may have this situation, especially again in real estate CIRP, where the number of allottees is large, their debt size is larger, and their debt size is more than any bank or financial institution. There could be a scenario also where the COC is a combination of an ARC and allottees. In that case also, this regulation becomes applicable. So if the claim verification, once our COC constitution exercise is complete for the first COC meeting, and we can determine that there are creditors in this CIRP who holds more than 66%, who are other than scheduled banks or public financial institution, then this regulation will become applicable and we will need to do a compliance. And what I will request, let us not take this so lightly. It's a very recent regulation. It has not been tested before the tribunals or any other court. One question when I was going through this regulation which came in my mind, it says unrelated operation creditors, absolutely fine. It says as observers only with no voting rights, absolutely fine. My question to me and to gathering is that operational creditors are not eligible to receive any confidential information, including copy of resolution plan. Now, if we are inviting them as an observer and we are to discuss the let us forget about valuation reports. If we are to discuss the competitive resolution plans with the COC, then what is their position? As observer, they will be entitled to receive that information. We can always take NDA and non-confidential undertaking. But this is a question because it's a recent amendment which we must ponder on, that if there is a certain confidential information which is required to be discussed in the COC, what would be the status of these observer operational criteria? Please think about it. I'm not offering any solution. I'm just making the gathering aware of these recent amendments. And again, coming back to the slide, there is again another practical example which I would like to share. Qua first COC meeting only. So first COC meeting, it's a convention that we put up the resolution for approval of remuneration of IRP, confirmation of IRP to RP, and remuneration of the RP. Now, I have recently I've recently come across a case law of Honorable NCLAT in which IRP were agreed for a lump sum remuneration of rupees 3 lakh for appointment as IRP and services of IRP. Now that IRP was replaced by an RP, but later on appointment of RP took substantial amount of time due to again litigation against the replacement by the IRP. And in the meantime, IRP continued to discharge his duties for several months. Ultimately, that IRP was replaced by a new RP. Now, what was the new litigation? The new litigation was that IRP stated that since I have worked as an RP, I am entitled to a monthly remuneration and not the consolidated remuneration of 3 lakh rupees. They even produce the that new remuneration chart, which is in the regulation, that based on the debt, this much is the remuneration per month remuneration, and that matter was argued before Honorable NCLT, and his application was dismissed. Matter reached the Honorable NCLAT, and what did the Honorable NCLAT decided? That first of all, IRP agreed, and the resolution regarding remuneration contained very clearly that for the lump sum remuneration for discharging these services as an IRP would be only 3 lakh rupees. That is one. That was one observation. Another observation was that okay, the regulation provides that until the RP is appointed, IRP will continue to discharge his services as an RP, but that does not entitle him for monthly remuneration unless that remuneration was approved by the COC. So that in brief, that was the outcome of the litigation. So again, though it is a convention to put the resolution of confirmation of remuneration, we have to be very, very careful about these things, that if we have to continue as an RP post without being confirmation as an RP, then how we have to put up our language for our remuneration. This case law I just wanted to discuss qua the first COC meeting. Again, okay, this is meeting. RP shall convene the COC meeting before 30 days. We all know that meeting frequency should be driven by the now. Now this was a amendment, though it's now a bit old, that there has to be a meeting every 30 days, but the COC can alter this uh, interval, and but there has to be one meeting every quarter. So my submission to the gathering is that meeting frequency should be driven by the progress of the CIRP, not by statutory minimum requirement. We may have to hold one meeting every month. We may have to hold two meetings every month. That totally depends on the circumstances. This provision was introduced primarily to tackle those situations where there was a substantial gap between two COCs and the RPs were not conducting the committee of creditors meeting, and it was one of the concerns raised by the financial institutions. This we have already discussed. Common first meeting agenda items. Regulation 21, it provides the basic contents of the notice of the meeting, of which we are all aware of it: date and time and venue of the meeting, facility to participation through video conferencing, detailed agenda, matters for discussion, matters requiring voting, relevant supporting documents, practical significance. A properly drafted notice often determines whether the meeting is productive or chaotic. Again, as I've said, that I will try to cover these slides with some practical example. So what I have seen, when there is a discussion on the resolution plan, which is the most important, or rather the only desired outcome of any CIRP, and I sit down either as the counsel for the SRA, or the RA, or the counsel of the COC, or for that matter, counsel of the RP, what I have seen, often the agenda is circulated only with the copies of the resolution plan in most of the cases. But my observation is, especially when it's a real estate, again, because real estate CIRP is one of the most complicated one, next to the going concern CIRP. When there's a allotee based real estate CIRP, the agenda, it would be better that if we can prepare a comparative summary of major points, cost timelines, refund in that in the comparative columns of the refunds, OTS timelines, implementation timelines. Better to attach 29 capital A DD report along with the agenda, because I have seen few of the IBBR disciplinary committee judgment in which RPS stated that he carried out a 29 capital A due diligence, but then it was stated that there was no report or cogent evidence on record by which it can be proved that comprehensive due diligence was carried out by the RP. So my suggestion would be that along with the agenda of resolution plan, a copy of 29 capital A DD report is also submitted. If we agree on it, some RPs don't agree on it. They say that the evaluation metric scoring is the job of the COC members. I agree with that. Technically and theoretically it is. But again, if it's a real estate CIRP where majority of the COC members are the allottees, it will not be out of place for us to at least do scoring from our side of the resolution plan and present a model evaluation matrix and leave the ultimate decision or scoring to the COC. Again, one thing which I have never seen, or I have seen very few example, that a 30 subsection 2 distribution is presented before the COC. 30 subsection 2 compliance is the most important compliance which the honorable adjudicating authority has to check. So if we can, if it is possible, practically possible for us, please prepare an Excel sheet in which you present the resolution plan value versus the liquidation value distribution as per 30 subsection 2, and now there is 30 subsection 2BA also. If gathering wants, I can just, since I have spoken about it, I can open IBC Amendment Act and just read 32BA. Yes. So this is again IBC Amendment Act. Again, why I'm saying this 30 subsection 2 chart, distribution chart, resolution plan value versus liquidation value distribution, why it becomes important. It says that in section 30, section 30 of the Principal Act, after clause B, BA, provides for payment of debts of financial creditor who do not vote in favor of the resolution plan in such manner as may be specified, which shall not be less than the lower of the amount to be paid to such creditor in the event of a liquidation of the corporate debt under section 53, or that would have been paid to such creditor if the amount to be distributed under the plan has been distributed under in accordance with prior order of priority on 53. If we will see the language of 30 subsection 2, existing 30 subsection 2, qua operational creditor, it is whichever is higher. But now, via this IBC Amendment Act, qua the dissenting financial creditor, which was a huge issue of litigation, now the law has provided that it is the whichever is less. So as I said, it along with the resolution plan agenda, it will not be out of place if we can present a 30 subsection 2 distribution chart, and of course key risk identified by the RP or any resolution plan. That if we can present that before the COC as part of the agenda, I think we have done our job. Quorum, we all know that it is 33%. Yeah, practical significance. Most COC meetings today are virtual or hybrid. I just faced very embarrassing situation myself personally. I hope that does not happen today. That when we were doing a COC meeting, there was a power cut, and ultimately the internet router gave away, and there was a gap of 5-10 minutes between the COC. So one practical suggestion from that experience I can give to the audience is, please have a very good UPS supporting your wireless router, so that if there is a power cut, so that 10-15 minutes gap can be covered by that UPS. Now liquidation. So with the first thing we have to note is what is a major amendment that has taken place in the liquidation regulation. Earlier, the liquidation was governed by the SCC model, Stakeholder Consultation Committee model. Now the amendment is the Committee of Creditors continues during liquidation. So the COC, which was earlier formed during the CIRP process, that will again continue during the liquidation process. So this is one of the major amendment. Again, the regulation 18 to 26 of CIRP regulation shall apply mutatis mutandis to the committee meetings during the liquidation. First meeting to be held within 7 days of liquidation commencement date. In CIRP, we all know it is 30 days. CIRP commencement date. The liquidator is required to place before the committee liquidation costs, status of legal proceeding, and progress of liquidation. Again, practical issue which may arise here. If the RP, which was continuing during the CRP proceeding, that would be continuing as a liquidator in these proceeding, then this compliance of this particular provision is not difficult. He has all the information handy with him. But you will see earlier IBBI introduced an internal circular based on which the adjudicating authority stopped appointing the RPs as the liquidator. In few cases, it was contested as well. Now, under the IBC Amendment Act, again, this provision has been given statutory mandate that the RP will not be able to continue as a liquidator. I'll read it. In section 34, for subsection 1, the following subsection shall be substituted. So entire 34 subsection 1, which governed the appointment of liquidator by the adjudicating authority, that has been substituted. It states, where adjudicating authority passes an order for liquidation of corporate debtor under section 33, it shall refer to the board for making recommendation of an IP to be appointed as liquidator, and on receipt of recommendation appoint such IP as the liquidator. So now that internal circular of IBBI, which was on which a lot of discussion took place, it was contested also. Now the statutory recognition has been given by this, that the existing RP will not be able to be appointed as the liquidator, and a new IP will be appointed as the liquidator. So if this is the statutory situation, then the question arises, first meeting to be held within 7 days of a liquidation commencement date, the liquidator is required to place before the committee liquidation cost, status of legal proceeding, and progress of liquidation. Even let us ignore this progress of liquidation. This liquidation cost alone, unless the previous RP provides this information within 1 day or 2 days of liquidation commencement date, it will be very difficult for new liquidator to put this liquidation cost and present it before the committee of creditors meeting. So the practical significance of this amendment is that 2026 amendment have fundamentally changed the liquidation practice. Conducting meetings during liquidation now follows a structured framework similar to CIRP. So we are on the agenda part of the COC meeting. So what I say, agenda is not merely a statutory notice, it is a decision-making document. Every agenda item should answer three questions. What is the issue? Why COC approval is required? What is the specific decision is sought from the COC? Now, I have given a practical example. During the examination of the resolution plan and supporting documents, it is noticed.
सर मेरा क्वेश्चन है यहाँ पर.
Yes, sir, please.
Sir, before going to the conduct of the meeting, it would be question for the reconstitution of COC after the amendment about the section 2111, the ongoing liquidation proceedings.
You are asking, sir, whether we will be required to reconstitute SCC?
Yes, absolutely. Yes.
I will open the liquidation regulation, sir. Which regulation you are referring?
We recent regulation 8, but section 2111.
Regulation 2111.
No, section 2111.
Section 2111 of the Act. Okay.
Yes.
Sir, I have not checked this point to be very honest with you, but since you have raised this question, it is my understanding that unless any amendment in law, unless it is stated to have a retrospective effect, it is prospective. That is one. But again, like I was discussing with this 32BA, so for any CIRP where distribution has not taken, a resolution plan has not been approved, I believe that this regulation 32BA would be applicable. But when you are saying that whether existing SCC will be converted into COC, I say any amendment unless stated to be retrospectively applicable, and if it is applied retrospectively, and it disrupts the entire process, I believe then it should not be applicable.
Section 2111 it says one ka B, the ongoing liquidation.
Let me open the Act, sir,
yes,
on the screen. Or rather, I have Amendment Act with me because new Act was not there on the website of the IBBI. So you are referring to section 21, right, sir?
21, subsection 11.
Let me come. It was amended by the recent IBC Amendment Act. Yes, it is here.
Yes,
this is section 21 and 11. Yes.
11.
Yes.
B class.
Let me read it.
Okay.
So where the liquidation process of the corporate debtor is initiated under Chapter 3, the committee of creditors constituted under this section shall also supervise the conduct of liquidation process by the liquidator. And the supervision of this section and 24 shall apply to such liquidation process under Chapter 3 as the context may require, provided the board may specify. And okay, it is hereby declared provision of this section 34A and 35(2) as amended to IBC Amendment Act shall apply to liquidation process of a corporate debtor initiated. Sir, it is clearly said after the commencement of IBC.
But clause B,
the ongoing process of the corporate debtor as on where the liquidator has not made an application. Yes, sir, it clearly says.
Yes. But it required to constitution.
Yes, sir. I mean, that's what I was saying.
Yes. But we come in the section 28.
Section 28 of this Amendment Act?
Yes. 28A.
Okay. 28. Yeah, this is one. 28?
Yes.
Okay. A. Okay. Notwithstanding anything contained in this code or any other law for the time being in force, where a creditor of the corporate debtor has taken possession of an asset of a personal guarantor. Okay, yes. This was regarding the personal guarantor.
Yes.
Or corporate guarantor of the corporate debtor by enforcing its security interest over such asset under any law for the time being in force, which empowers the creditor to transfer the asset. The creditor may, during the CIRP, permit the transfer of such asset. This is something different, sir. What is your question?
बस my question is proviso देखें इसका सर एक बार.
Proviso.
यही पर मेरा question actually.
ये वाला, this one is proviso. Okay.
Yes.
Proviso that where the corporate guarantor is undergoing CIRP or the liquidation process. Okay. Transfer of the asset under this subsection shall take place on the approval of the committee of creditors of the corporate guarantor
Yes.
by a vote of not less than 66% of the voting share, and
Yes.
the amount received pursuant to the transfer shall form part of the CIRP process or the liquidation estate of the corporate guarantor. Okay.
Yes. But my question is once during the CIRP, in my assignment, here the financial creditor filed his claim as a corporate guarantor. कॉर्पोरेट गारंटर की जो मतलब जो सीडी है
CD is a
taken
corporate guarantor.
ना सीडी इज
हाँ,
कॉर्पोरेट गारंटर
ठीक है.
फाइनेंशियल क्रेडिटर हैज फाइल्ड द क्लेम and relinquish his security, but this amendment is not come into force in that time, so we allow the participation in this COC. But now
Okay, your company is in liquidation, right?
yes, liquidation.
Yes. Okay.
But now is the absolute commencement of this regulation 8 of regulation for the constitution of the COC. If his security he relinquished, but really his security is not existence, then we allow the participation in GC or not.
Sir, this is a slightly different question which touch upon the valuation of the security interest which has been provided in this IBC Amendment Act. What I can understand from your question that your financial creditor was existing as a COC member.
COC,
CRP.
yes.
Now and he was appointed as a SCC member also.
Yes.
SCC member also. Now your question. Security interest has nothing, and he has relinquished, of course, his security interest.
Yes,
then
yes.
only he became the SCC member.
Yes. But his security he relinquished, but existence is not there. Security है ही नहीं है रियल में. तो उसका हम ट्रीटमेंट क्या करें? सिक्योरिटी रिलिंक्विश माने या ना माने?
So this question I cannot answer just like this. It's a bit technical thing, and I need to look at the documents. But what your question was correct, that this section 21 now it says that as far as possible, this amended section 34A and 35(2) will be applicable to the ongoing liquidation also of the corporate.
And constitution also there as per the regulation 8.
Yes, that to that extent you are correct. But this particular case of yours, that it will be very difficult to answer in this forum.
So we have the dilemma position ki how to allow the
कोई amendment आएगा अनूप sir, there will always be dilemma. There is no doubt about that. तभी तो litigation चलता है.
We disallow the participation, immediately challenge the NCLT. Earlier that he allowed the participation, but that now he is outside.
Now we are disallowing it. Yes, of course, it will be a challenge. So coming back to the practical example, during the examination of the resolution plan and supporting documents, it is noted that one of the proposed strategic investor identified by the resolution applicant is a relative of the suspended director of the corporate debtor. Now, as an RP, we identified, it is clearly stated that he is a mother, father, son, brother, anything or relative of the suspended director, one of the strategic investor by an independent resolution applicant. My suggestion would be that agenda should include a relevant extract from the plan where there is an introduction of the strategic investor, relevant extract about what is the role of that strategic investor, relationship chart if available with us, that how the that person is a relative of the suspended director, some preliminary observations of the RP, and of course we need to carry out a thorough due diligence. So agenda should include what time we need to conclude that due diligence, and if we need to appoint an independent advocate for obtaining a legal opinion that whether such kind of a resolution plan qualifies the test of section 29 capital A or not. So the introduction of that advocate, and of course the approval for fee. So this is again it's an experienced gathering. This is one of the example that how we as far as our agenda would be detailed, it will be easier for COC to understand and later for us to defend that decision of the COC. This slide continues about this example only about the strategic investor. That specific approval that may be sought from the COC in this scenario would be to take note of the material development and requirement of detailed due diligence exercise, to approve the estimated additional time, if any, required by the RP for completion of section 29A exercise, to approve engagement of an independent legal counsel for obtaining a legal opinion on the issue, to approve the professional fee for obtaining such legal opinion after considering the comparative quotations. Key learning: the resolution professional should never seek COC decision on the eligibility of the resolution applicant. We have seen some disciplinary orders on this regard. The RP role is to independently examine the compliance with the code, while the COC role is to take informed commercial decision after being apprised of all material facts and approving resources necessary for a legally sound CIRP. Yes, some I would encourage now a little from the gathering. These are some of the scenarios that I have identified based on my experience. Like there is a dominant financial creditor. We must have seen in our CIRPs, whenever there is a creditor who holds substantial or majority of voting share, they always try to dictate their terms, that how the CIRP or has to be run, or in what particular manner the RP has to act. So these are some practical approach we have given. Although this approach is not a thumb rule, there are varying situations, there are varying circumstances, there are varying nuances which we have to keep in mind while discussing a dominant financial creditor. But I would like to give an interesting example in one of the CIRP where the RP handled the dominant financial creditor in a very tactful manner. So it was a largest public sector bank and they had the majority share and they were the original Section 7 applicant of the IBC. So during the first COC meeting, the gentleman who was representing as an officer of that financial institution in the CIRP, he started speaking in a manner that I have done so many cases. I have been part of this big CIRP, Uttam Galwa, SR Steel, and everything. So he was presenting his view in a manner that the CD does not have enough asset to cover the debt. So the COC should either consider selling these assets outside of the CIRP, or they should consider the liquidation, they should consider the dissolution. And he was suggesting all many things which is ultimately the duty of the RP. So the presiding RP, and I really appreciate the acumen, the presiding RP stated that you are the original applicant of Section 7, and in the very first COC, you are saying that you don't see any option of resolution of the CD. So why did you file the Section 7 application? If there was no resolution, there was no chance of resolution. And that was it for the rest of the meeting. That gentleman from that largest financial institution did not say anything, and the meeting proceeded as per the prefix agenda. So this is one practical approach which we can always take. Be polite, but be firm before a dominating financial creditor. This is important ambush agenda item. Suddenly someone says during the course of CIRP that please take up the agenda of replacement of the RP during the mid-meeting. What could be our response? The matter falls outside the circulated agenda notice. We will record your formal request and introduce it as a distinct agenda item in the next meeting after providing due notice. So we need not to, immediately take a decision if a financial creditor suddenly introduce a agenda item which cannot be covered in that COC meeting. Demands for confidential data. Handing over of valuation or forensic report to the suspended management pressure. At times, I have seen during the CIRPs that the representative of public financial institutions try to pressurize the RP to provide this kind of confidential information to the suspended director. At the end of presentation, I'll cover two NCLAT judgment, and both are on this aspect only. This is important. Personal accusations. Letting the meeting devolve into an emotional mudslinging between promoters and bank. So what could be our practical approach? These are just example. What I have seen from my experience. We are recording only the elements directly material to the current agenda. Personal or disputed allegation belonging in their respective legal forum. Let us bring focus back to the item 3. Let us come back to what is the discussion in the CIRP. So these are some of the example handling of difficult stakeholders practical approach. This I have by and large cover already. 2026 amendment, every IP must reflect in the meeting. Committee of creditors continues during the liquidation. Liquidators now conduct the structured committee meeting similar to CIRP. Familiar meeting procedures continue into liquidation. CRB meeting regulation applies to liquidation meetings. So these two slides I have dedicated, but by and large, we have already covered this discussion. Again, some reports. These are some of the common mistakes that I have tried to collect at one place regarding this topic. Agenda circulated without adequate background material. Every agenda item should be accompanied by explanatory notes, supporting documents, and a clear draft resolution wherever approval is sought. Seeking blanket approval from the COC. I had one again, very practical example of this. Recording incomplete or one-sided minutes. So I'll give you again a personal example of mine in this on point number 4. So a gentleman who was an RP in a CIRP, he approached me to represent him before the IBBI in a disciplinary proceeding. What was one of the allegation was that the financial creditor stated that the entire COC meeting concluded and we were not even allowed to speak, not even a single word. So when this gentleman approached me, I asked him that how it is possible that a 35 minutes COC meeting took place and financial creditor is the sole COC member is making an allegation against you that he was not allowed to speak. So you will be so surprised. It's a little funny also. He said that he was in during the entire course of COC meeting, the sole COC member was on mute, and there was some mistaken setting from my side, due to which he could be unmuted from my side only, and he could not unmute himself from his side. So I kept on speaking during the entire meeting. And I thought he had nothing to say, and I just concluded the meeting and recorded the minutes. Now he was saying that you are a very good advocate. Please cook some story before IBBI. So I was very surprised. I was rather baffled. I asked him that for 35 minutes, you kept on speaking on your own and you did not even realize, had no discussion with the COC member at all. And you thought that there was no requirement of any discussion. So, I mean, there could be a scenario of one-sided minute that some discussion took place and we only recorded our part of it in the minutes. But how it is possible that the sole COC member did not utter a single word during the 35 minutes of COC meeting? And I also commended the person that for 35 minutes you kept on speaking on your own as if like you were giving a PPT presentation. So, I mean, that was kind of a blunder which I'm sure none of us will be doing. But this is something that recording or incomplete one-sided minutes, even if there was a submission from a COC member which we do not like, which we do not agree, but it is our duty to record them in minutes. If we try to sideline that, every COC meeting now take place in a virtual mode, recording is available. Later on, that can be challenged, those minutes can be challenged, and it can become a trouble for us. Again, this theme will keep on coming in my presentation, sharing confidential information without examining legal permissibility. And why this keep on coming is when I will discuss at the end of presentation those two ironclad judgments, then now all will realize that how important this is. Please read this. Every notice, agenda, presentation, and set of minutes should be drafted keeping in mind that they may later be scrutinized by adjudicating authority, appellate tribunal, or IBBI. This is the bedrock, in my view. This is the bedrock of a IP practice, RP practice, that whatever document we are preparing, whatever email we are sending, even if we are sending 1,000 email during a CRB process, every document, every email should be drafted by us in a manner keeping in mind that later on it will go through the scrutiny of adjudicating authority, appellate tribunal, or IBBI. If we are able to do that, I think 90-95% we can be sure that will not be subject to any adverse scrutiny at the hands of the regulator. Next slide is a bit important because this is the real world practical example. Lessons from recent IBBI disciplinary committee orders. Now, what is the common thread? the common thread is the overwhelming majority of severe IBBI disciplinary action do not stem from fraud or dishonesty. They stem from process failure and defensive documentation gaps. Please see. Extreme meeting delays, example, no meeting held for 455 plus days. Even if no practical reality check, 2 year suspension was handed over in this scenario. Even if no active vote is scheduled, you must call periodic meetings to update the stakeholders on cash flow, asset health, and ongoing litigation. Even if nothing is happening, please hold a COC. Please tell them why nothing is happening. There must be some reason for nothing is happening if CIRP is going on. Because if we don't do that, then it becomes a very problematic for us later on before IBBI. And you can see a 2 year suspension. This was not the only reason, but this was one of the reasons. Timeline failure, failing to time. Now I have, when I represent the RPs and whenever they come to me for filing of a extension on exclusion application, I have always a one request to them that please file the extension application at least week 10, 12, 15 days before the deadline, because otherwise honorable NCLT always come down very heavily if we file it on the last date or post expiry of the CIRP period. Again, compounded into a 2 year suspension. Information asymmetry without withholding critical analysis or documents from the COC. For example, that strategic investor example which I was taking, if we have obtained a legal opinion, if we have prepared a due diligence report on that aspect, please do share those documents with the COC. All those things will, number one, help the COC to take an informed decision, and those documents, that trail of communication, will also help us later on defending ourselves before the regulator. This was, though it is not strictly again in the realm of COC meeting, but still it came during my research, so I have done this. I put this here in the PPT. This is important. This I have seen over and over, and I discussed this also during the presentation. Retaining control over bank accounts or records after being replaced. I don't know why this happens, that if we are replaced from the IRP to RP or RP to liquidator, there is not all, but in some cases I have seen that there is a reluctance to hand over the affairs and the documents to the incumbent or the newcomer RP or the liquidator. So again, in one of the cases, this was dealt heavily by the IBBI, and a 2 year suspension was granted. Practical checklist. Again, we are all very experienced professionals, and we know all these things. Again, one practical scenario which I saw in one of the CIRP, in which the financial creditor raised a severe objection during the CIRP, that the notice did not reflect their correct voting share, and due to that, the quorum was not properly assessed by the RP. So, if between two COC meetings, we have admitted any new claim, because of which, especially again, I would say in the real estate CIRP, where we have admitted any allottee claim that delay has been condoned and the voting share has changed, please do take care of the verification of quorum, and proper voting share should be defined in the agenda item. After the meeting, prepare balanced and accurate minutes. We have touched it. Record objection, dissent, and important clarification. As I have said, even if we don't agree with the objection, we don't like those objections, please record them properly if those were stated by the COC members. These are some 10 important commandments for practicing IP that I was able to prepare. Never place an item on agenda without a clear specific outcome or decision attached. Own your duties. Do not delegate the decision that code explicitly commands you to make to the COC. Protect your practice. If an issue is ambiguous, secure an independent format legal opinion. Again, we have discussed this, the question of strategic investor being the relative of the suspended director. Minutes must narrate. Your minute should tell the comprehensive story of why a decision was made, and not just that what final voting count was. Never surprise the COC. Circulate all material data well in advance. Respect every single stakeholder, but maintain strict independent distance from all of them. Aggressive timeline management, keep your statutory countdowns under continuous daily review. Log the reason and context for major decision all the exact moment they occur. Assume complete scrutiny. Assume that every single notice, agenda, email, and minute you create will eventually be closely examined by the NCLT, NCLAT, or the IBB. I have just said that. Process is your shield. Flawless process and defensive documentation are your strongest legal protection against disciplinary action. So this, by and large, completes my presentation on this topic. I have only those NCLAT judgments to discuss with the gathering. If there are any questions, if any discussion is required, just like the discussion we just had with Anup sir, I'll be willing to do that. Anybody, any question, any discussion? All right. So shall we discuss those judgments which I have been referring to? Those who have, those who are present, I request now some serious attention. These are the live real-time judgment which are taking place and the discussion is still going on. This is the judgment of Honorable NCLAT Chennai bench, and it is, you will be very interesting. It will be very interesting to note that it's a split judgment. The judicial member gave one judgment, the technical member gave another judgment on the same issue, and now the matter is currently being argued before the chairperson court in New Delhi. The next date of hearing in this matter is 22nd of July, and then only we will be able to know what is the final outcome. What was the issue in this? Why this matter reached the Honorable NCLAT? The issue was that during the crucial 20th COC meeting, where resolution plans were evaluated, the representative of suspended director was asked to leave the hybrid meeting after 15 minutes. The RP and COC member cited two reasons. First, he did not possess a specific formal written authorization letter from the suspended director, and he did not execute the required confidentiality undertaking. So from here, the entire dispute cropped up. The matter went up to Honorable NCLT. Then it met to Honorable NCLAT. And it's again, why it is so interesting? Because it's a split judgment. I will read the important paragraphs of this judgment for our benefit. So first portion is from the judicial member, Honorable Justice Sharad Kumar Sharma. Okay. Para 20. Under the regulations of 2016, the word authorized representative was inserted by notification dated so and so with effect from so and so, which contemplates a mandatory process of appointment of an authorized representative who is to be selected as per the regulation for the purpose of representing the cause in the proceeding, which are held under the I&B Code 2016. As soon as it is being determined that a person is not holding a proper authorization, he is incapacitated from participating in the COC meeting. This was the first observation. It goes on. If a general connotation is taken pertaining to an authorized representative on its simple reading, as it has been provided under the NCLT rules under Rule 26, it would mean a person authorized in writing by any party to present his case before the tribunal as a representative of such party, as provided under the Act. Similar is the expression given to the term authorized representative in the context of the procedure contemplated under NCLAT Rules 2016, particularly contained under Rule 2D, which 2 means a person authorized in writing by a party. So the emphasis of the Honorable Judicial Member was in the authorization should be in writing. The precondition to make a person as an authorized representative to represent a cause of the other would be only when the appropriate legal authority is vested by virtue of a writing, giving an authority to represent. In the absence of the same and in the context of the aforesaid rule of NCLT and NCLAT, respectively, do not bring Mr. Neluru Bapuji, who was the representative of the suspended director, as to be a person competent to hold an authority to represent the cause of the CD. Hence, on that ground itself, the meeting of 20th COC cannot be faulted off in any manner whatsoever. There could be another logic for not accepting the appropriate contention apart from the legal embargo emanating from the regulation, and else also the general definition of authorized representative would be that, admittedly, when a proper authorization and confidentiality affidavit was not available on record, the representative of the appellant will not be having authorized right from the date of inception of the COC meeting to represent the cause of the applicant. The question which would ultimately emerge would be as to whether at all there could be a submission of a de facto authorization after the meeting, which could revalidate the authority in relation to a concluded meeting. So the honorable member went on, and it says stated, on a perusal of the record upon issuance of the notice 12th July 2024 as referred herein above, it is absolutely false on the part of the appellant to submit that the representative of the appellant was not permitted to attend the meeting. He attended the meeting, but when the aforesaid discrepancy, which was the lack of written authorization and confidentiality undertaking, was figured due to the lack of proper authorization and non-providing of required confidential undertaking, he was asked to leave the proceeding of the 20th meeting, which was held under a hybrid mode. So ultimately, the judicial member concluded as follows. And so far as the 20th COC meeting is concerned, we have already held that representative of the appellant had suffered from illegal infirmity in participating in the COC meeting. He was rightly ousted in the absence of a valid authorization having been executed in his favor or in accordance with the law, as argued by the learned senior counsel, that despite of the fact subsequently confidential understanding was issued on so and so date, and it was filed on so and so date. In fact, the attempt which was being made by appellant was to delay the proceeding, which was also observed by the Landlord Tribunal in the impugned order. Thus, the dismissal of the same by the impugned order is absolutely justified for the reason which we have already observed in the body of the judgment. Hence, the appeal lacks merit and the same are accordingly dismissed. So, the honorable judicial member was of the view that since the representative of the suspended director did not have the authority in writing, so the fact that he attended the previous COC meeting without that authorization does not make it correct to continue once it has been identified and it has been pointed out to him, he has no right to continue in that COC meeting. So they held the decision of RP and COC ousting that representative of suspended director as correct. But the honorable technical member took a different view. I will not read all the entire paragraphs. I'll just read the conclusion, and it was a very big conclusion. So what did the honorable technical member concluded? They said that when that representative of suspended director was allowed to participate in the previous COC meeting without any valid authorization, it was incumbent on the RP, first of all, to ensure that those meetings should not have been attended by him without authorization. And even if it was pointed to him that he did not have that valid authorization, that authorization should have been obtained and he should have been allowed to participate in order to give effect to the judgment of Honorable Supreme Court in Vijay Kumar Jain versus Standard Chartered Bank. So what did the honorable technical member concluded? Accordingly, the minutes of 20th meeting will also stand quashed and CIRP will start from the stage of 20th meeting of the COC after giving copies of resolution plan and relevant document to the appellant being the suspended director. The aforesaid action needs to be done within 2 weeks from the date of this judgment. Thereafter, RP will convene the meeting of COC within 2 weeks in which the appellant will also participate. The COC will then proceed to deal with the resolution plan as per the procedure detailed in the code and the regulation frame thereunder. In case the CRP period is over or the timeline may be extended suitably by excluding the time spent in litigation. So the honorable technical member, in his view, in his judgment, even quashed the entire 20th COC meeting and ordered that the CRP should be started from the date of the 20th COC meeting again. So this is the far-reaching impact which can have on a CIRP for in the manner in which a COC particular meeting is concluded. Now this matter is, as I've said, pending before the split judgment matter is pending before the Honorable Court of Chairperson. And let us see what would be the outcome of this. Any discussion on this judgment? It's a very important judgment. Anyone from the participant, please? All right, I'll take the next judgment. Now, in this case, this is NCLAT Delhi. In this case, again, the issue, what was the issue? The issue was non-sharing of valuation reports by the suspended directors by the RP. Ultimately, they were not provided with the valuation reports. The matter reached the Honorable NCLAT and various judgments were discussed, and ultimately it was stated by the Honorable NCLAT. I'll just read the conclusion somewhere. Although in this case, again, there is an interesting aspect, or the regulations were discussed. It was determined by the Honorable NCLAT based on the past decision that, okay, Vijay Kumar Jain was the Standard Chartered Bank judgment of the Honorable Supreme Court states that the directors are entitled to receive the copies of the resolution plan and all the documents pertaining part of the notice and agenda. But the valuation reports are never circulated to the COC as part of the notice and agenda. So, and even the regulation does not provide for. So it is not mandatory for the RP to provide the valuation reports to the members of the suspended board. In this case, however, it was noted that RP has acted in a fair and transparent manner in supplying the documents, including valuation report and plans to the appellant. Later on, there was a revaluation done in the CIRP, and the RP provided the valuation reports, though I'm not sure why that was done. But the entire crux of judgment was that the valuation reports are not mandatorily required to be shared with the suspended board, even pursuant to the judgment of Honorable Supreme Court in Vijay Jain versus Standard Chartered Bank. So what I'm trying to say with this presentation and all discussion of this two Honorable NCLAT judgment is that the conduct of a COC meeting is the soul of the entire CIRP. The way we conduct the COC meeting, the way we prepare the agenda, the way we prepare the minutes, the way we record these deliberations and prepare the documents, that by and large determines the outcome of the CIRP. And the more meticulous we are in preparing those documents, the better it will be for us to defend ourselves before the regulatory authority and adjudicating authority. So honestly, I could not prepare more material on this, considering the fact that all are experienced IPs. This is the end of presentation from my side. I'll be happy to take any questions. Anybody from ICSI IIP? Madam, I have finished my presentation. If there are any questions, I will be happy to take those. Otherwise, if there are no questions, I'd like to take permission to leave.
Participants, if you have any questions, please ask.
No questions on my side.
All right, sir. Thank you very much.
Anybody has any question? Otherwise, we have to conclude the session.
There are no questions, madam.
Okay. So thank you very much, sir, for giving your valuable time and sharing your inputs on the topic, effective COC meetings and other meetings. Now there is lunch break till 3 p.m. Next session will start at 3 p.m.
3 p.m. Thank you.
Thank you, ma'am.
Good afternoon, madam. Hello. Am I audible, sir?
Yes, sir, you are audible. Shall we start, sir?
Yes, madam. I am ready. I am ready.
Participants, if you are there, can we start?
We can start. Yes, we
Okay.
can start.
Yes, yes.
Good afternoon, everyone. Now the session will be taken by Siva Prasad, sir, on the topic maximizing value of corporate data through asset valuation under IBC. Let me briefly introduce Siva, sir. Sir is qualified CS, cost accountant, professional in finance, commerce, insurance, and banking. He is having experience of 36 years in banking and financial services with cross-cultural experience and good knowledge in insurance sector. He has handled senior level responsible positions with higher level interaction and exposures. He has authored number of books and study materials for the professional institutions like ICSI, ICMAI, ICAI, IGNU, IIBF, Insurance Institute of India, Mumbai. Now over to you, sir. Kindly start, please.
Okay. Thank you, madam. First of all, thanks to ICSI, IIP for giving an opportunity to discuss about the maximizing value of the corporate data through asset valuation. So everybody knows about the maximization. It is one of the concept in the preamble of the IBC. But to my experience, some of the particularly CIRP process or liquidation process, the complaints are raised by the various stakeholders. And sometimes they are approaching the IBBA also, particularly the disciplinary committee. Why the IPs are not looking into the value of the property properly? So thereby, the aggrieved parties, they are suffered a lot. And some of the IPs, particularly the RPs, even though the market value of the property is X, they are selling the property X minus 1 or X minus Y like that. Why they are doing? Even though asset valuation is there and two values are to be valued, and in case a third value is required, why the variation is there, third value is also there. And even in the IBBI or IBC, the three types of valuation is there. One is land and building and plant and machinery, and the securities valuation, etc. For all these things, a lot of comfort is there. But at the same time, the IP, while choosing the values should be experienced person and independent. Whatever the valuation is giving, no pressures, no forces, external forces should not absorb. Whatever the value is there, that value to be declared. Even in the bank also, in the banking system, because I am from State Bank of India, in the banking system also, particularly in State Bank of India, once the value is given, the valuation, that is not the final. The branch manager or the credit officer or credit relationship manager or credit analyst, he has to inquire in the market whether that particular property valuation, what is it? He has to declare the final value, not the valuation of the particular value. We are taking that as a base. The technicalities and all these things are there. Particularly one building is there in a prime locality. The branch manager may not aware of what is the strength and what is the construction quality and whether how much cement or iron, whether it is a good construction or not, all these things, technicalities he is not aware. But through the market valuation, market people, or getting information from the market, he will finalize the value. Surrounding people or the particularly whatever the registration number in that particular place or the new constructions that are happening in that particular and the age of the building, all these things he will take into the general information, he will take into consideration and he will finalize the value, and accordingly he will certify the value both by the credit officer as well as the boss, particularly either branch manager or the higher authority like that. But in the similar manner, every time I am telling, particularly in IBC, the law is 40% and 60% the managerial abilities or skills are required for the RPs. Because you are the CEO of the company. Each and everything you should know, whether it is a production process or marketing channels or the particularly the technology or the finance or the human resources, whatever the functions are there. No, sir, I am not having that background means then it is a problem. Even today, the banks are also, while giving the advertisement, they are asking sectorial experience. Once you are having that sectorial experience, then only it is a good to the corporate, they particularly the company which is undergoing the CIR. So 40-60% mix. So here, take for example, the law, the IBC code, only 252 or 256 sections, or the regulations from time to time, thanks to IBBA, they are giving a beautiful regulations, clear and crystal regulations, and even they are publishing the judicial pronouncements also. So that's why the major area of the resolution professional managing the company in a better manner when compared to the other RPs or when compared to the earlier corporate data. The skills have to be developed. Here, the maximizing value, particularly asset valuation, the three important assets valuation is very, very important. Once the valuation is less, the last people, once the valuation is correct, the last person should get some share in that sale process or through the resolution plan. Okay. 50% of the cases where no assets are there, nothing is there. I am not talking about that one. The going concern assets, the going concern companies. So, one question, it is lingering in my mind also. Once the balance sheet is balanced, the assets and the liabilities are balanced on 31st March every year. Suppose one company is there, the company is particularly undergoing CIRP. The balance sheet last year, 31st March 2025, the assets and liabilities are matching. So once the assets are sold, it should be appropriated to the liabilities up to equity shareholders. But that is not happening. In that case, what is the purpose of the balance sheet? Once the balance sheet assets are there, assets are 100 crores, liabilities are also 100 crores. Once the assets are, one principal is also there in the assets. The market value or the book value or the actual value, whichever is less. Suppose one building is there, one building cost 10 crores. But if at all the depreciated value as per the book is only 1 crore, I am putting 1 crore only. Next 9 crores, that per amount is also there. So, if at all the assets are valued with the market value, it is much more than the liabilities. Once the liabilities are, the assets are sold or assets are given to the resolution, the applicant through the resolution plan, up to last equity shareholders should get. That is not happening. I'm not talking about where there is no assets, the assets are alienated, and the particularly long 10 years back only it was closed. I'm not talking about that companies. I'm talking about the live companies. 1 year back company or 1.5 year back company that is comes under CARP process. Once the balance sheet is balanced, the assets are there, liabilities are there. The assets, if at all valued for market value, it is much more than the balance sheet value. Once it is much more balance sheet value, the liabilities are no market value. Whatever the actual liabilities I have to pay. So always assets are much more than the liabilities. Then lost person and the appropriation of payments or waterfall mechanism, the equity shareholder, he should get it. That is not happening. Either the balance sheet is wrong or the valuation is wrong. Some of the people, particularly I am reading that a particular disciplinary action. One property, 450 crores, but it was given to the resolution applicant for 200 crores. Okay. The value maximization, the efforts are to be made by the RP. Simply 450 crores, if it all the RP is given for 200 crores, is it a profession? So that's why maximizing value of the corporate data, that is one of the primary duty of the resolution profession. You see that the disciplinary actions, and even recently the Institute of Chartered Accountant IPA also they have released one book. In that book also valuation number of cases are there, and complaints they are giving to the disciplinary committee of the IBB, and they are escalating this issue to the adjudicating authority also. Now I will discuss about the in detail about the various assets, how they are to be valued, all these things. Even debtors, the asset, good assets, the debtors, but simply debtors recovery efforts are not made by few RPs. Once debtors are there, and maximum, particularly the debtors are to be recovered. The debtors are giving a bill of exchange, debtors are while the goods acknowledgement or purchase order, all these transport document, all are available. Once it is available, you can they file a case against the debtor and recover the amount. There is no bond. But patents, copyrights, even though the company is not having a building, even though the company is not having machinery, even though the company is not having the land, etc. And in the pharma companies, the patent their values are much more than these values. The buildings are landed buildings. The IPR, intellectual property rights, particularly in pharma companies or technology-oriented companies. So the value maximization is one of. So that's why today I will discuss about all these things up to 6 o'clock and 4:30 we will take the break. Now coming to the value to employees, the value to investors, the value to customers. So once you are arriving a conclusion, all people should satisfy. The stakeholders, that's the broader name is stakeholders. Maximizing value of the CD through asset valuation or IBC 2000. That is possible. but our involvement should also be there. Valuation is given simply, it is mentioned in the information memoranda, and whenever the resolution plans are submitted, you are matching. That is not the criteria. Whether the valuation is correctly done or not. Prima facie, I'm not talking about technicalities. How much a measurement, how much a concrete structure, or what is the strength of the wall or strength of the building, under what material they have used, that type of information already provided by the the valuer. What is the resolution of professional duty is to verify the valuation report also. Then only the stakeholders may be the financial creator, the stakeholders may be the operational creator, the stakeholders may be the employees, the stakeholders may be even the investors, the preference shares and equity shares or government, all stakeholders should satisfy. Once the balance sheet is balanced, assets are matched with the liabilities. The Insolvency and Bankruptcy Code 2016 was enacted with the primary object of ensuring time-bound insolvency resolution. Once the time-bound is not happening, value maximization will deteriorate. Suppose I am in my company, one machinery is there. Today, if at all I sold 1 crore, it will come. I am not doing any maintenance. I am not running the machinery. The wheel of the machinery is not moving. After 6 months, due to that breakdown, particularly I am not using rusting and dust and all these things, people will ready to purchase 1 crore property with 50 lakhs. Because the maintenance is also one of the important. Or early the better, the resolution plan should be early the better. Once the resolution plan, the process is completed, the 330 is the upper limit. 180 plus 90 plus 60, that is the upper limit. It doesn't mean some of the cases with 90 days also it is possible. That's why the fast track is also implemented. The fast track system is also there. And maximization value of the assets of the corporate data. Because the assets, each and every asset, I should not give the asset free or less amount to the prospective resolution applicant. Whatever the value is there, 5% that side or this side, there is no problem. But a haircut, lot of haircut, and a promotion of entrepreneurs. If the assets are not released properly, and a haircut is 80% or 90%, in future, no investor will invest in the investment company. Nobody will invest. Once I invested in the company, after that the company turned into bad on account of liquidity problem or the financial problem, and the company is facing with the CARP, we don't get any review boss, only they will secured creditors will get up to equity shareholders, we are the investors, we don't get means, then the particularly investment made by the prospective investors will also not interested to invest their hard-earned money in the industries. Availability of the credit. Even banks also, whenever they are giving loans, and 100 crores they have given, they are recovering 10 crores, means 90 crores loss is there. The loss is to be borne by not by the bank, that is the depositors. Why? Because the banks are doing the business with the help of a depositors fund. Bank is only the intermediary. They are collecting the deposit from the public and they are giving loans to the public. Once the public is not paid, the ultimate sufferers are the depositors. But only Deposit Insurance and Credit Guarantee Corporation up to 5 lakhs. Suppose the depositor invested 1 crore. Once the bank is in doldrum, he will get only 5 lakhs. And the promotion, availability of the credit, balancing interest of all stakeholders. Once this amount is realized to certain people and certain people deprived, then that is also not correct. That is also not correct. So that's why the IBC preamble also clearly state all these things. All these things. And among these objectives, maximization of value assets occupy the central position. That's why it is mentioned in the preamble of the IBC code. Because of success of the CIRP depends largely upon the realistic valuation of the corporate data. That is not happening. Even in economic times, all these things are business line. We are seeing that haircut 90%, 95%. Once the balance sheet is balanced and the assets are the 100 crores and the liabilities are 100 crores, why the equity shareholders are not getting the funds? So the realistic valuation, no forces. Everybody should get it, because that is also hard-earned money. Whether it is a equity shareholder or preference shareholders, they are also investors, or debentures or bonds, along with the operational creditor and financial creditor. Even a financial creditor also, not only the secured creditor, unsecured financial creditor, operational creditor. Once the operational creditor is not getting their funds during CIRP, in future they don't allow any creditors. Once the credit is not given, like financial creditors, operational creditor also, if they are not giving any credit, definitely the industrial growth will not happen. So the CIRP depends largely upon the realistic valuation of the corporate data. Realistic value. I am not asking a higher than the original value. And even today, some of the assets, particularly land, is there. Land, not only the registration value and whatever it is there, if at all it is a prime locality. And if in future number of companies are coming, means the land value will appreciate like anything. So valuation is one part, market value is another part. Asset valuation is not merely accounting exercise. Some of the people, they will length, breadth, height, the depth, and what is material used. All these things is the part of the valuation report. But beyond that, and it is a ready-made building, ready-made industry. And if at all new investors are there, through prospective resolution, they are ready to purchase, they are ready to pay more amount also. Today, to construct a company, 5 to 6 years. Once the ready-made company is there, even though the valuation is X, but ready-made, that is also to be factorized. The market value to be factorized. And instantly we can run the company. That's why the goodwill is also to be taken into consideration. Goodwill is not only for success companies. Ready-made pay. Some people, if I invested today, after 5 years only the production will happen. In the meantime, my funds are deadlocked or blocked. Thereafter only I will get the realization. But if at all I purchase a company, which is the instant the action it will be initiated, the resolution applicants are ready to pay. That is the bargaining capacity will be more to the certain companies from the corporate data companies. It forms the foundation of preparation of information memoranda. For preparation of information memoranda, this is required. Attracting resolution applicants, proper valuation. Okay, if at all some company today, some companies, even though the value is there, construction value, but market is not there, means the value will come down. Oh, no investors, the value will come down. So the valuation is different, not only based on the measurement and accounting system. Beyond that, so many factors are contributing. Attracting resolution applicant, determine the liquidation value, assessing the fair and evaluating the resolution plans. Simply, the forensic auditor, they will give the report, evaluation, they will give the report, public announcement, the media, the print media, they will publish, and whatever the claims are there, the staff, they will verify and collect. What is the role of the RP? The professional judgment, the professional analysis, all these things are required. So, assessing the fair value, evaluating the resolution plans, enabling the COC to take informed commercial decisions. So, the RP has to put forth all these things. It is not the decision of the RP. He is a facilitator. He has to analyze. He has to appraise all these things to the COC. An inaccurate evaluation may either discourage potential investors. If at all the valuation 90% cut is their haircut, or the total realizable value 90% haircut means in future nobody will invest in the companies. Everybody will invest their funds in banks. Banks are also not interested in giving the loans. They will invest in government securities. Once they are particularly the banks also, once the NPS too much, NPS are increasing, banks will also stop. That is called a narrow banking. That is called narrow banking. Narrow banking means once the loans are turned into bad, banks will mobilize the deposit and they will invest in government securities. Thereby the safety, the sovereign of the state will give the guarantee. That is a 100% guarantee. So the potential investors are result of substantial value erosion, thereby defeating the objectives of the IBC. The objectives of the IBC should not be disturbed through our acts, through our work and other things. Therefore, valuation professionals, resolution professionals, committee of creditors, registered valuers, financial institutions, resolution applicant must understand the principles and methodologies of valuation to maximize the recoveries for the stakeholders. Today, one company is there. Okay, that the company, they have not handled properly. Thereby, whatever the loans they have taken, that is defaulted. And the banks are filed with the IBC. Very good. But once a ready-made company is there, leave it of the valuation of the accounting valuation like that. Once instant cake is there, the instant even brew and the brew, instant brew is there, instant brew is there, normal coffee is there, instant brew cost. There is no additional preparation time. Only the powder to be put in the milk and mix it and give it to the concern. But in case of ordinary coffee, I have to boil and I have to filter it and later on take the coffee. Time-taking process. Wastage will happen. While boiling the coffee powder, wastage, all these things are. So that's why when compared to a construction of a new company and an instant company with the reasonable modification, that is fine. People are ready to, but it depends upon the efforts made by the RP. It depends upon the efforts made by the COC, other people. The objectives of the asset valuation under IBC. The valuation of process of IBC seeks achieve several objectives. It determines the intrinsic worth of the corporate data based upon the existing assets, the future earning capacity, the market potentiality, the intellectual property, and the business prospects. That is called the intrinsic worth of the corporate data. Existing assets, values will give existing assets based on the invoice and based on the depreciation, etc., etc. Some other assets, simply they are deducting depreciation, but once the usage is not there, the depreciation to be calculated in a different manner. And the future earning capacity. Suppose the same time, sometimes the machinery may not be available in the market. To place the order of the machinery, it will take a lot of time. Market potential and intellectual property, right? IPR. Some machinery, only limited machineries are available in the business prospects. Once the demand is there, number of players are not there, definitely the product is required by the customer. Here, the valuation depends upon the other factors, not the accounting or other things. It provides a benchmark for a committee of creditors. And while evaluating the completing the resolution plans. So the resolution plan, depending upon the information memoranda is depending upon the proper valuation. All are interlinked. All are correlated. It assesses the resolution apply in preparing commercial viable bids. Resolution applicants, it assesses. Suppose if at all you have given the correct valuation, suppose take for example, even in our house, the old articles are there. Whenever we are selling, are you showing to the buyer with the dust and all these things? We are clean it and we shine it. Then only the prospective buyer will quote higher amount. One example I am quoting. One sofa set is there in my house. And the color, because on account of usage, some dust and color lightly changed. Lightly changed means not the original color, on account of dust and other things. That urban ladder people, I spent 500 rupees. And neatly that particularly they have cleaned with some soap, and now it appears like a good sofa. Then I they proposed to sell that sofa. Earlier, my quote is only 3,000, but on account of that 500 spent 7,000 I received. Here, I am not, this is not the criteria, but I am giving only the example. Even company also, whatever the company is there, I have to do something better than the others. That is my motive, not the sofa and other things. It's a resolution applicant preparing commercial viable bids. It protects the stakeholders undervaluation or overvaluation of the asset. So it is nobody should get extra. I am not asking you to cheat the buyer. That is a prospective resolution applicant. Whatever the fact is, the fact to be disclosed properly. If at all you have not disclosed properly, then the stakeholders will be deprived of the benefit. Once you are the higher amount, nobody is ready to purchase. Always, I am not cheating the others. The realistic value of the asset is very much required. It promotes transparency, confidence among the lenders. Once the value is realized, the secured or unsecured financial creditor, operational creditor, and the wages or the government taxes, and all these things are there in the balance sheet, along with the assets. Liabilities are there, assets are there. But while selling, assets are realization is a very less means. But at the same time, assets are only the book value, not the market value. Market value is much more than the values that are declared in the balance sheet. It promotes a transparency and a confidence among the lenders, investors, employees, and operational greater and regulatory authorities. If at all everybody is satisfied, the growth of the industry will happen. If at all they are not satisfied, they don't invest. Once they are not invested, then industrial growth will not happen. Unemployment will increase. Government, once industrial growth is there, government will get their taxes or different benefits will arise. So that's why asset valuation is one of the important area in IBC. Legal framework for governing asset valuation. The provisions relating the valuation contain particularly what are the acts that are covered for asset valuation. IBC code is same, value maximization, and insolvency resolution process of CIRP. Some regulations are there, and the company registered values rules are also there. IBBA guidelines relating to registered values are there, and internal valuation standards are also there. Indian valuation standards wherever applicable. Some legal framework is that legal framework in toto that is to be implemented while valuing the various assets of the corporate data. Under Regulation 27 of CIRP, the resolution professional is required to appoint two registered values. Here, I am not valuing and valuing the one person. I am taking two persons. Today, what is happening? In the bank also, whenever I am giving the valuation, the valuer will, sorry, previous valuation report, if at all it is there, you kindly provide me. Kindly provide me means he is not going to the physical verification. Simply based on the old record, whatever the market appreciation is there, he will add it. What is the current status of the asset? Whether asset is a dilapidated condition or good condition or bad condition, the physical verification is very much required. Even if at all you are identified two values means the different people. If you appoint different people, no problem. Even other state people also. One state this one, other state. But there is no regulation rules in this regard. But correct valuation is your the role. So fair value and the liquidation value. The valuation remains confidential. We should not reveal to others. And shared only with members either entitled regulation after confidentiality and undertakings. Whenever it is given to the COC member, we should not reveal to anybody. Even valuation part, sir. Being a banker, I worked in State Bank of India for 36 years. Even the valuers, some of the borrowers, they are they're managing the valuers also. And when the latest valuation, normally the banks will not take for enhancement. So this year they will value the property with a higher amount. Next year they will ask us, 1 year back, sir, I have given, I'm not taking the latest valuation. 1 year back only, that is a bubble rate. And they are asking. Then as a branch manager or the credit officer, we will go to that particular register office. What is the land valuation, survey number, surrounding survey number, what is the latest registration value? We have taken that amount as a base and accordingly we will calculate. We are not completely bank on or depending on the value certificate. It doesn't mean that I'm not telling that the valuation is wrong, but your role is also there. Whether why the complaints arise? Why the complaints are raised in the NCLT or NCLAT or IBBA disciplinary committee? The RP has a value, they taken some known persons and the valuation 400 crores, but the report is given 200 rupees. Some disciplinary action initiated certain RP subs. Go through that the disciplinary actions initiated by IBBA, that booklet published by ICAI, IPA. The valuation reports confidential and shared only with members entitled regulation after obtaining the confidentiality under. Role of the registered values. The registered values role is also there. He should be independent. Even RP told, no, boss, you give less amount or you give more amount or whatever is the direction, don't listen. But some of the people, if at all don't listen, sir, definitely next time I will not get it. That is a different issue. That is out of syllabus. That is not part of the regulation. That is not part of the code. That is not part of the preamble. The registered values are independent professionals registered with IBBA, registered values organization. Independent. They should not listen. Whatever the exact realistic value of the property is there, he has to. Their responsibilities include physical verification of assets. That's why during my tenure as a credit officer, I don't share the old valuation report. Boss, if at all you are want to go, if at all you are going to that place, we will arrange the conveyance or we will arrange the payment. Why you are asking old? Why you are mentioned in your the CV or biodata that I am having 20 years or 25 years experience? Why you are asking a previous report? What is the purpose of the previous report? Then there is no answer from the most of the values. So the some of the people in the four walls in air conditioned room, whatever the earlier report copied and pasted and some the changes, structural changes they will do and give it. And valuation report is a costly one also. And we are debiting to the borrower's account. That is also not correct. The valuers should visit. Some valuation takes a lot of time, 13 days or 15 days or 1 month. It depends upon the size of the company. Study the financial statement. The values should verify the financial statement. Whether in the financial statement it was what he has mentioned, you ask why it was mentioned like that. And site inspection is required. And market analysis. What type of a machinery, what type of a building, whether it is a market, what is the market analysis, whether this type of a plant and machinery is available in the market or not, if what is the rate, and whether it is a domestic or imported, that is also to be verified. Industry analysis. Some of the industries, particularly pharma, the machinery valuation is more because that is to be imported from other countries. Lot of time, the customs duty or whatever, the time and letter of credit, all these things, lot of time, 1 year. In the meantime, instantly it is available under CIRP. Even though the present value, there also some of the plant and machinery, even after taking depreciation, appreciation value is also there because that type of machineries are not available instantly. But this machinery is instantly available, then they can run the production, commercial production. Determination of the fair value. Both parties should not suffer, either buyer or the seller. The buyer is the resolution applicant. In our case, the seller is none other than the corporate debtor, the CIRP, the COC, /RP. determination of liquidation value. Even distressed value in banks also we are mentioning distressed value. If it all enforced sale, now itself I should get the funds means at what rate? At what rate it will available? Preparation of valuation reports. The valuation reports should be prepared, elaborative, and particularly the chapterization is good. And how he is valuing. Even common man also should have the knowledge about how he value. But today, what is happening? They are using the technical words and jargons and other things. The linkages, the structure is missing. And they explain the assumptions adopted. While giving the valuation reports, some assumptions are there. Suppose I take, for example, I have taken only comparison with the two companies that are operated in India. I don't know the others. Some explaining reasons why you are putting that value, why not that the higher value. For that also assumptions based on the life of the machinery, based on the quality of the material that is used for manufacturing that machinery, all these things. Their independence is extremely important since the commercial decision of the lenders depends significantly upon their valuation. That's why starting point of what I told, once the balance sheet is balanced and the 1 year back only, the 100 crores assets, 100 crore liabilities, once the assets are sold, all liabilities have to be clear. Why it is not happening? Once 20 years or 30 years, in the meantime, alienation of properties and all these things. I'm talking about the live companies. Even a balance sheet also, one asset, State Bank of India, the simple example, State Bank of India, Nariman Point, Mumbai, nearly 20 crores, the building is there. It may be 200 crores or 300 crores, but book value of the asset is 1 rupee. Even 1 rupee, I am arriving the balance sheet, but that is called secret reserves. So here, definitely, all balance sheets, whatever the balance sheets they are preparing, they are mentioning book value. The market value is entirely different. Simple example, the building of the Nariman Point Mumbai is a book is 1 rupee in the balance sheet book, but whereas the 300 crores or 400 crores like that. So that's why the valuation is very important. And excellent assumptions, the independence of the extremely important since the commercial decisions of the lenders depending upon the significance of the valuation. Even for valuation also, don't be hurry. Don't be hurry means you should not take months together. First of all properties are properly valued by the bankers while giving the loan. In the credit appraisal, it is available. In the credit appraisal, it is available. That too, every 3 years, banks are updating the valuation. First, take the base and keep that information. The COC members are the monitor, you are supporting to the COC members. Definitely, whatever the valuation reports that are there in the banks, 1 year back or 2 years back, at the most 3 years back, get that valuation reports and keep it with you. Once the valuer is valued that property, why the differences arise? That you have to do. That you have to verify. Types of values under IBC. Fair value. The fair value refers the estimated realizable value of the assets. If exchange on the insolvency commencement date between willing buyers and willing sellers. after proper marketing without any compulsion. It assumes the orderly transaction. This is called fair value. So the buyer, the seller, they are agreed for one price. That's why the valuer, while valuing the property, it should match with the fair value. Why once the valuer is valuing the property, and if at all he is wrongly valued less amount, immediately some of the cases resolution plans automatically will come, and sometimes the valuation haircut is there. Why haircut? Whether RP is not publicized that information through widely to all the people who are the prospective resolution applicants available across the country. Marketing efforts are also required. Today in my area, if at all I am giving advertisement, okay, whatever the registered, the one local and one national, that is as per this one. But here, wide publicity is required. Whether you are putting on the corporate data website or IBBA website or whatever, this one is there, the request for a resolution plan or the expression of interest, wide publicity is required. Liquidation value refers the estimated realizable value if assets are sold individually during the liquidation after consideration of forced sale condition. No, I have to realize at the earliest. If the liquidation time is 12 months, I have to sell it off all the assets and appropriate the same and forced sale. I need not wait more time. Normally, the liquidation value is less than the fair value. The liquidation value is less than the fair value. And enterprise value. This is a third value. This is a best value. This is a going concern value. This is a total company should be given to one person. Both will be benefited. The purchaser will be benefited. The enterprise value represents the value of the business as a going concern. It includes the tangible assets, the intangible assets of the company, the future cash flows of the company, and brand value, the customer relationship, technology, human resources, license, goodwill, all. Today, whenever you are selling the pharma companies, the licenses values are very, very high. How the valuer is valuing that information? You have to see whether he has given proper attention for that particular licenses, even brand value. Some of the particularly Bambino or MTR, still people Colgate or the different companies, the brand image is there. So the brand value is more. But brand value means if at all the CIRP is dragging, then brand value will deteriorate. Because that brand is not available in the market, the people will purchase the other brand and they are accustomed with the other brand. The brand value will be realized more in the earlier days of the CIRP. So the human resources also. The human resources trained people are there. Suppose that today, experienced, not experienced. Experienced people, instantly results will happen. No experienced people, learning curve should be slowly increase. The slope of the learning curve, slowly it will increase. But experienced people, the learning curve is fast. So once it is a going concern, you have to value the human resources also. Sir, this is CFOs. or the production manager, the HR manager, the marketing manager, the finance manager, the research and development, these people are there. Value them. Earlier, human resource accounting system is there. But in India, it is not implemented. But in developed country, in the balance sheet, human resource accounting is also there. So here, the human resources also very important. That is also factories. Suppose only one industry is there. Suppose I take, for example, industry location is one area. In the location, nearby location, nearly 100 villages are there. So whatever the casual labor problem is not there. Otherwise, if at all you are started a industry in elsewhere, you have to migrate the people and you have to show the accommodation and all these things. Once the industry is there, surrounding 100 villages are there, labor problem is the labor problem will not arise. So hiring the labor is not a problem. Suppose I take, for example, one industry is nearby river is going, you have to take that river also because of water problem will not arise. Water problem will not arise. Some industries, they require water. So all these things, whether the valuer is factorizing or not, that is the look after of the resolution professions. Resolution applicants generally estimate the enterprise value while submitting the resolution plans. Importance of going concern value. Once the wheels are moving, the value will increase. Wheels are not moving, the value will decrease. To move the wheels, additional expenditure is required. Once already wheels are moving, then instantly I can take over the company and run the company. I need not incur any additional cost. The IBC strongly encourages the preservation of the corporate data as a going concern. That is the rational. Why going concern? So once the employee is already there, one employee is already working in one organization. Once the recruitment is happening in other companies, the employee who is now working, they will take instantly. Once the employee is experienced, but last 1 year he is not handling any job, then the value of the particular person will decrease. So that's why the going concern. A function of the business generally commands a significantly higher value than the individual sale of the goods. Once you are not at the bits and pieces, then it is a value will deteriorate. Plant, land, stock, or others. Once all are assembled, the value will increase. If all are disgruntling, the value will decrease. For example, a running cement company may fetch 1,200 crores. The same plant sold piece by piece during liquidation, they will get only 600 crores. Thus, the preservation of the business continually directly contributes the value maximization. So, as far as possible, even though recently the going concern concept is not there in the liquidation as per the new amendments, but still my personal opinion is the company should be run up to the sale of the company. Indirectly, that is the best. Category of the assets requiring valuation. Whatever the category, valuation extend beyond land and buildings. Beyond land and buildings, everybody is looking what is the land, what is the building, or what is the plant and machinery. Our plant and machinery rusted, only the we have to sell to the second-hand iron stores like that. No. Beyond the building, land and buildings, the important asset categories are, the first is the land. What is a land? First, you open the assets register where the lands are purchased by the company. Assets register that is available in the company. Because it is an annexer. For preparing the balance sheet, the assets register closing balance will be reflected in the asset side. And whatever the depreciation is there, normally the land, no depreciation. Appreciation. Particularly if at all it is a coal mine or any minerals, over a period of time digging, then the land value may be deteriorated. Otherwise, appreciation. The building, the size of the building, the concrete, what is used, and the strength of the building, and what is the present value. Even building also, when a going concern means not running the wheel, even all assets are to be in a good manner. Once the assets are looks like good, appreciation automatically. Whenever I am going to the gold, and first they will polish that particular the plate, silver plates, and they will show in the light to get more the instant purchase. It doesn't mean that a silver plate is a bad silver. It is a good silver. But if at all it looks catchy and the location and all these things are in a good condition, definitely the price will increase. Even in marriages also, the same thing will happen. And the plant and machinery, furniture, the furniture should also, whatever the waste furniture, throw it. If at all unnecessary, dead asset, provide 100% depreciation and sell in the market as a second-hand furniture. Vehicles, whatever the running vehicles, maintain in a good condition. Whatever the old vehicles are not useful and not worth to repair, dispose it of. Inventory. In inventory also, dead stocks are there. Fast-moving stocks are also available. If at all fast-moving stocks are there, orderly manner, dead stocks provide 100% depreciation and sell it for second hand. Raw materials in inventory consists of three. Inventory consists of raw material, semi-finished goods or work in progress. Third one is finished goods. In inventory, three types are there: pure raw material, semi-finished goods, and finished goods. So this is the required. The categories of the assets require valuation. Not only that one, investments. How much investments the company has made? Where you take the investments register and verify for the last 3 years. If at all investment is sold 1 year back before CIRP, why it was happened, whether he is a related party or not, what is the prevailing market price at that particular date. For PUF transactions also, the forensic auditor has to verify this one. Loans. Whatever the assets, whatever the liabilities are there for that, schedules are there in the balance sheet. Verify the schedule. Verify the schedule. when it was purchased, what is the invoice number, what is the life, what is the depreciation, all are available in the assets register. Loans, receivables, the bills receivables, or account of receivables, or debtors, all are one and the same. With bill of exchange, without bill of exchange, like that. The receivables register is there. For that receivables, what is the credit policy of the company? How many days they have to pay? If they have not paid on due date, what is the rate of interest to be charged? All are available. The receivables, their address, how much time they have given, whether it is a 10 days or 15 days or 20 days or 30 days. After that, how much rate of interest? You have to verify bill of exchange is in live or acknowledgement of debt is there or not. Once it is live, if give the notice and if not paid, file it in the court to recover the amount. That is an asset. The trade receivables and security deposits. For bank guarantees, they will give security deposit. For letter of credit, some security, physical fixed deposits. Or sometimes they will give the property security deposits. Particularly for franchise, security deposit. So all the security deposit schedules are there verified. Yeah, take the balance sheet last 3 years. Okay, current is not available, at least last 3 years. If last 3 years is not available, before 3 years, and cash balances. How many accounts are opened at the bank, current account? How many banks? Some of the companies, they will open a State Bank of India, Canara Bank, Punjab National Bank, that cooperative bank, this RRB, regional rural bank, so many banks they are opening. All are having the details available in the annexes. Why the amount of what amount they have received recently? Why they have withdrawn, to whom they have paid, whether the amount is used for the particular director's interest or not, fraudulent transaction. You have to guide to the particular, the forensic auditors. All these things are part of the resolution professions. Some of the people, some few people, they are thinking that RP means IBC code. RP means the regulations issued by IB. That is only 40%. If at all any going concern company handed over to the RP, he is the CEO of the company. He has to run the company. Finance, marketing, production, human resources, all these things you have to handle. Valuation reporters today, some of the, my friend, one friend, he's never bothered about to open the particular the valuation report also. Whatever the amount mentioned, that is populated in information memorandum. Intangible assets. It is not visible. Brand. What is the present brand value? Nirma washing powder, that small girl, while coming to the from that particular, that is the daughter of that particular company person. When she came from that particular, when she came out, returned to home from the school, she is a happy mood. In that happy mood, she is revolving, and that is a beautiful picture. That's why that is captured and make it as a logo of the Nirma washing powder. Logos, brands, the reputation of the company in the market. Tata, some reputation is there. Hindustan Levers, some reputation is there. So I'm not talking about that companies under CIRP. So many companies that goodwill is also there. Local brands within state, trademarks and patents, patent rights. If at all they are manufacturing any machinery, the patents or copyrights or software, they are using the software also. That software no company is using. But on account of software, good results will happen in the company. Licenses. So many licenses. And different companies, different licenses are there. For arms and ammunition, that is military equipment manufacturing, some licenses are required. Or pharma, some licenses are required. Or different companies, to get the license, it takes a lot of time. And 6 months, 1 year also they have to struggle. Even pharma, to get a license, instantly online is not available. ISI or Indian Standard Bureau of the Industry Standard, that is also instantly now. FSI, particularly food related, instantly not available. That is having some value. But always some of the people, they are always looking about where is the land, where is the building, where is the machinery. If a machinery is the old machinery, leave it up as first land and building. No, other than land and building, so many intangible assets are there. And the customer contacts. Suppose one company is there, their customer database is 1 crore, full value. Their cell numbers, their email address, their particularly address. Take for example, Amazon. Only customer database if they sold to others. Crore, 1,000 or 2,000 crores or 3,000 crores they will get. My address, my email, my cell number, my preferences of goods, all the data is available in Amazon. If Amazon assets are not there, if the Amazon is under CIRP, even the customer contacts will quote crores of rupees. Database. Today, over a period of time, the database, particularly the companies, they acquired that database. That is also costly. That is also costly. And they have not paid, but their customer database is available with them. So some companies, they are purchasing the database for marketing their products. Sir, are you getting my point, sir? What I am telling? Sir, madam. Hello, am I audible, sir? Hello, am I audible?
Yes, sir.
Okay, sir. Intangible assets, digital assets. Some companies, data centers are there. Amazon data centers. So many places, data centers are there. Their data is stored. Even banks, data centers are stored in a different location. My State Bank of India data center is located in Navi Mumbai and Hyderabad and Chennai and other places. Digital platforms, that is also value of the asset of the company. or customer database, just I told, software codes, particularly whatever the software they have purchased, now they are using even the software 100% depreciation. Suppose accounting system software the companies purchase for 30 crores. As per IT income tax rules, 100% depreciation is possible. Once 100% depreciation is provided on the IT, then it will disappear from the balance sheet. It doesn't mean that the asset is completely used. Over a period of time, once the IT software developed, then I can use a number of years. Even banks are also core banking system is there. So by this time, once they incur some amount, 1 or 2 years, that will be completely right now. Are they providing depreciation and it will disappear from the balance sheet. For the last so many years, banks are using the same software, core banking, cloud infrastructure. Some of the companies, they are going for cloud, that also. And artificial intelligence models. The recent companies, they are adopting AI models for providing services or providing the manufacturing goods. They are using AI. That is also value. Domain names and digital payment infrastructure, etc. All these things, digital assets are also there in most of the companies. Valuation methodologies. What are the valuation methodologies that are there in but 3 internationally accepted approaches are generally adopted. 3 internationally accepted are generally adopted. What is those methods? Market approach. First is the market approach, valuation. Under this method, similar company assets are compared. Example, comparable companies, multiple recent acquisition prices, listed company valuations, etc. So the market approach, similar company, same type of production, same type of a product or the volume of transaction and market within domestic market, the companies are comparable market approach. This is suitable for real estate. This is suitable for listed companies and commercial assets also. Advantages. Reflects market sentiment and easy to understand. So similar building, if at all you have taken in X place, this is a value. This building also in X place, this is also similar value. And the limitations. Comparable transaction may not exist. Sometimes similar locations, similar company may not exist. Market conditions fluctuate. So that's why the limitations are there for this approach and advantages are there, suitable for a real estate, listed companies and a commercial estate like that. Cost approach. This is a second method based upon the replacement or reproduction of cost. Machinery. Once the machinery is replaced with a new machinery, how much it costs and what is the present value? They are valuing the cost approach. They are taking the cost approach also. Buildings. The buildings. It's the same building. So the building size, the floors, all similar cost. The construction value, how much? And the per square feet, what is the construction value? What is the life of the particular the building? And how much depreciation based on the life? Specialized industrial assets. All these things are cost approach method only, less suitable for business having substantial goodwill. Even though this method is applicable to so many industries, but a substantial having substantial goodwill. If some companies having more goodwill, this approach may not be possible. Factors affecting asset valuation. Several factors influence valuation. First one is internal factors. So the company valuation depends upon the profitability of the company. If at all I have purchased and run the company, whether I am going to get a profit or not. The cash flows. Once the company is I purchased and operated, whether regular cash flows will happen or not. Capacity utilization. And at present, the company is at 50% capacity. Whether I can go for 100%, the market absorption is there or not. Management quality. The present management is weak. I'm going to purchase, then I may get more profit. And if the management is strong in the present company, and why they are not getting profits, that question mark will arise. Technology also very important. Once the old technology is implemented and another company, new technology is there, the old technology and the new technology companies, the difference will happen. And the employees' skills, and the employee skills are good, definitely it adds to the valuation. And the product quality. If the product quality is good and good reputation is there in the market, definitely the valuation will increase. Litigations. So many litigations, customer litigations, staff litigations, regulatory compliances, violation. If all these litigations are there, the value will decrease because the prospective buyer is not interested to purchase that company. Because once he purchases the company, he has to handle the litigations. Thereby, valuable time will lost. Valuable time will lost. External factors. Industry outlook. The inflation. The industry outlook and inflation. So, the industry in future, whether this industry demand is there or not. And inflation is also, once the product price is increasing, whether people are absorbed or ready to purchase the product, law of demand means once the price is increased, demand will decrease. So on account of inflation, the product price will increase. Suppose you take, for example, gas related company and crude oil or petrol or diesel related companies. Today, on account of that supply is less, inflation will increase, the product price will increase. Whether the customers are ready to pay or they will switch over to other product or not, or they will stop the consumption. Interest rates and exchange rates, the interest rates that are offered by the banks. If at all more interest rates are offered, more interest rates charged by the banks, nobody will purchase. And if exchange rates, volatility more. Today, Indian rupees and dollar, the rates exchange is widely changing. And Indian rupee valuation is a decrease and dollar appreciation is happening. And if at all it is an export goods, then exports will become costly. And the exports will become cheaper and the imports will become costly. All these things are to be taken. Government policy. The government policy about the company. Suppose a plastic company is there. The government is not interested. They told clearly this type of the plastic to be manufactured, not others. Thereby the ecosystem will damage. Competition. If a number of players are there in the market, the competition will be more. Competition more means survival is a question mark. So the competition and environmental regulation and ESG compliance also. So the environmental regulations, too much environmental regulation is there. That is required also. Once the company is not satisfied with the environmental regulation, then penalties will attract. Once the penalties are more, then so ESG compliance. ESG compliance. Now, this information, whatever the information is, the valuation is they are going to get, that is useful for preparation of information. The information memoranda prepared by the resolution professional contains the financial position of the company, the asset details of the company, the various liabilities that are there in the company, the security interests that are there in the company, the litigations are there in the company, and what type of contracts are in force, or how many employees are there, and the business operation, whether the business operation going concern or standstill or valuation assumptions. All these things the company will take into consideration. The information memoranda enables a prospective resolution applicants to estimate the business value accurately. For that purpose, the valuation of assets are very, very, very important. The valuation of assets are very, very important. The role of the resolution profession. RP plays a vital role in the valuation also, not simply identifying the people, giving the as they endorsing the work of evaluation. That is not the role. The real role is after the valuation, before valuation also, he has to identify the assets properly, and all assets are to be given to the, not in a piecemeal manner. If at all plant and machinery identified and ask them to value, and whatever the data or bills receivable or whatever other assets are there, all these things are to be informed to the valuer in a written format, in a letter format. Not simply you value the building, you value the plant and machinery like that. What are the terms and conditions? What are the confidentiality agreement, and whatever the other areas are there, all are to be mapped to the particular the value, providing records, ensuring confidentiality, and appointing RP place, appointing registered values, only the IBBA values. Even still, some of the people, even valuation also, they are using their relatives, friends. Then that is not correct. And if that is happened, these issues are raised by the corporate attorney, facilitating asset inspection. And once the values are appointed, you have to tell to the company in charge, whoever is the production or different department heads, that this person is appointed, he will do the valuation like that. Providing records. You have to give the records when it is purchased. What is the invoice? What is the depreciation provision? All these things are to be informed to the particular valuer, ensuring confidentiality. You have to take a declaration from the valuer that I will maintain the confidentiality and the coordinating valuation. You have to coordinate from time to time what is happening, and a timely valuation report, accurate valuation report, that is also required. Maintaining neutrality. You need not tell, you give the higher valuation or lower valuation, whatever the realistic valuation is there that and substantiate the particular valuation also. But at the same time, the COC role is also there with regard to valuation. The evaluation of the COC utilizes a valuation report. For what purpose? To evaluate the resolution plans. So based on the valuation report only, the COC will evaluate the resolution. Once the wrong valuation is there, wrong resolution plans will submit. Compare bids. They will compare whoever is giving highest bid. Negotiate improved offer. Different people, they will improve the offer. Assess the commercial viability. The commercial viability is also very important. Assess the commercial viability, whether it is a commercially good or not. Decide between the resolution and the liquidation. So, which is the best one? Even at the time of a day 1 or day 2 or day 3, the RP has to assess whether the company should be continued under CIRP or liquidation. Sir, why it is not? Once a COC is formed, after a collection of all the claims, you have to decide. Before COC, you will get a lot of information from the company. Once you are continuing as a going concern under CIRP or liquidation, which is the best one, you have to decide. If at all you are continuing as a going concern, the value of the company is deteriorated and the losses are increased further, it is better to go for liquidation. You should not contribute. You should not contribute loss to the company on account of your efforts or on account of your skills. On account of your efforts, the skills or efforts, the value to be maximized, not to be deteriorated. Once the deterioration is there, then prefer liquidation and accordingly you recommend to the COC for liquidation. But you have to substantiate the answer. Why I am going for liquidation? Why I am going for CIRP? Why I am going for CIRP? And assess the commercial viability, decide between the resolution and liquidation. Although valuation of the COC is not bound to accept bids equal to fair and liquidation value, if a better commercial outcomes are achievable. Accept the bid equal to fair or liquidation value if a better commercial outcomes are achievable. That is the role of the COC. That is the role of the COC. Next one is role of resolution applicants. From their role also, what is the role of RAs? The enterprise values, synergy benefits, and future profitability. Whenever they are submitting their proposal, they have to look into these areas. Whether I have to purchase based on the enterprise value, or what is the benefits I am going to get, and what is the future profitability, first they have to arrive. Thereby, they can go for higher bids, etc. In case bidding is there. Industry growth, they have to look into what type of industry I am going to purchase, whether that industry growth is happening in the market or not, and what is the market share, particularly this company earlier, how much percentage of sales in the market they contributed, that is market share and capital expenditure. Once I have taken this company, how much additional capital expenditure I have to provide, operational efficiencies. Once I purchase this one, whether it is operationally efficient or not, I have to decide. And the additional expenditure, if at all additional expenditure, if at all I incurred, what benefit I will get it. They frequently offer values substantially exceeding the liquidation if future prospects are promising. Once the future of the company is bright, definitely they will offer more price than this one. So this is the role of the resolution. And now the maximizing value during CARP. That I will discuss after tea break for 10 minutes. Is it okay for all, sir? Shall we take for tea break? Hello?
It's perfect, sir. Thank you. Much needed break.
Okay.
Yes, sir. Yes, sir.
Thank you.
Yes, sir.
Now I will start, sir. Maximizing the value during CARP. Value maximization depends on proactive actions during CARP. Proactive. This is not a defined any place, either in regulations or code like this, or judicial pronouncements also. Continuing business as a going concern. Going concern concept, because some of the companies, I'm not talking about 50% of the companies, they are not suitable for going concern. But some companies are suitable for going concern. Timely payment of a CARP cost and preserving employees, maintaining production and protecting customers. If you did like this, do like this, definitely some value will increase. Timely payment of CARP cost. Once the CARP cost, particularly raw material, is there, during CARP period, whenever the operational credit are supplying to for that period only, after CARP, whatever the raw material purchased with the company or the wages of the workers, if you paid that in time, that is a part of CARP. Or if at all any interim finance is taken and the interest or installments are paid, definitely value maximization will happen. And preserving employees. Don't allow the employees to, today, ISRO is there. ISRO. Nearly 120 to 125, the 100 to 120, the officers are going to resign and they want to go outside. Immediately the government of India immediately pay attention. Why they are going? What is the reason? Whether they are not getting any adequate salaries or not? All. Once all people 120 to 100 to 125 people are left the ISRO, then in future rocket launching of from India will not happen. Rocket launching will not happen. Whether it is the PSLV or GSLV, whatever it is, it is very difficult. So now government raised to the occasion. Why? What is the reason? Do you think that salaries are not up to the mark? Or they are thinking on that to retain the employees? Here also, if at all key manager persons left and the employees are left, going concern is not possible. Again, from scratch onwards, recruitment is not possible. Once a recruitment is there, their learning curve is very less. Preserving employees is very important. Maintaining production. Once the machinery wheels are moving, then automatically the value of the machinery will increase. Once the machinery is halt due to rusting, definitely the value will deteriorate. The production is very important. Protecting the customer. Even though you are having so many problems of the company, but I should not leave the customer. Retention, particularly to acquire the new customer, so many times cost instead of retaining the customer. Retention of the customer, even banks also, to retain the existing customer is very, very important. Okay, to acquire the new customer, lot of cost is there. But the retention is easy. Their database is available with you. And whatever today, the company is in CARP, or tomorrow, definitely that is to be given to the prospective resolution applicant. The product delivery problem will not arise. The same thing you have to tell both to the employees as well as to the customers also. Marketing assets globally. So whenever the resolution plans are taken, limited area, if no resolution plans are not there, definitely the value will decrease. Number of buyers or resolution applicants should be increased. Inviting competitive bids and providing accurate information memoranda. Whatever the information memorandum detailed, it is a marketing brochure. It is a marketing brochure of the corporate data. And whatever the information you are giving, it should be accurate. It should be if at all the prospective resolution applicant they want to verify the cross check with the company records, it should match. It should match. And transparent bidding process. And some of the people, particularly resolution professionals also, they are doing some wrong things. Thereby the reputation of the profession is also lost. Even if you see that ICA, IPA or triple IP, they have published a book, disciplinary cases. In the disciplinary cases, what type of actions are initiated by the disciplinary committee? Some of the people, they cancelled the certificate of practice, and some people, they awarded some penalties, etc., etc., and avoiding unnecessary litigation. Preserving intellectual properties, whatever the intellectual properties are there, value that one, and once the intellectual properties, you have to appraise the matter correctly to the prospective resolution application. And unnecessary litigation. Don't invite unnecessary litigation. If at all valuation is wrong, definitely corporate data will file an application with the NCLT, or they will go for a Supreme Court also, Honorable Supreme Court, and maintaining statutory compliance. Whatever the listed companies statutory compliance are there, follow that one. Whatever the MCA compliance, follow that one. Whatever the pollution or environmental issues are there, follow that one. Whatever the during CARP, if at all any taxes like GST or income tax is there, during CARP, not the earlier one. If at all any dues are there, promptly paid to avoid the litigations. Importance of intangible assets. Many modern companies derive a major value from the intangible assets. Even though I told earlier also, one pharma company is there, they don't have the buildings and other things, but IPRs are there, or licenses are there. It is much more than land and buildings. The proper valuation, where it is, how many are there? You verify with the finance manager or production people, they know about all these things. Example, pharmaceutical patents, software, telecom company, Spectrum, software company, some the intellectual, the assets, the intangible assets are there. Customer database, that is a valuable one, sir. If at all the company is having 1 crore customers, that is because of their address, their name, their date of birth, their email address, their cell number, all are available. So for marketing this database, now the companies, they are selling this database also, which is an intangible. It is never written in any the balance sheet, banking licenses, insurance licenses. Suppose the company is dealing with the IT company is dealing with some banks, particularly for software fintech companies or insurance, insurtech, the licenses are also there, and e-commerce platforms. That is also a valuable asset. And never reflect software, whatever the software is, it is not reflected in the balance sheet. Because as per the income tax rules, 100% depreciation in first year itself. Once they purchase their software, in the year end, the provision and the depreciation is made, it will disappear from the balance sheet. But the software, valuable software, and artificial intelligence models. Today, every company they are using in the production, they are using in other areas, the AI tools. But the AI is also a software. Once the software is purchased first year ending, it will be 0 eyes on account of the depreciation 100%. Hardware means hardware also 3 years, but still hardware. Even one example I'm quoting, banking, core banking solution is there. State Bank developed 2003. And 2 years, the total software 100% depreciation is provided. Till date, the same software we're using 23 years with the patches in editions, etc. The editions also within 1 year we will write off. So the pharmaceutical the customer database banking license, e-commerce and artificial ignoring intangible assets may lead to severe undervaluation. Ignoring intangible assets, if at all you are ignoring intangible assets, definitely it is a undervaluation and a challenges in asset valuation. Common challenges are outdated financial statements. Because once you are taken that a particular assignment, by that time balance sheets are not available. Or once balance sheets are available, it is a long back balance sheet, missing of asset register. So you want to see the all assets, whether it is a stock or plant and machinery or intangibles or patents, copyrights, whatever it is there, that is not available. Title disputes. So some companies titles disputes are there. The disputes where it is, nobody knows. And the staff is also not cooperating. Encumbered asset, unencumbered, not encumbered, and on that assets loans are taken. And we have to verify the MCA website and section 77 charge creation or CERSI under Surface Act 2000, the central registry. The whenever we are giving loans to the anybody, that is a more immobile property, even mobile property also, we have to register and CERSI, CERSI. It is a central registry for all the assets financed by the banks, and a lack of comparable transactions. And obsolete machinery. Sometimes the obsolete machinery is available, it is not sellable. Environmental liabilities on account of water pollution or air pollution or sound pollution, some penalties are happened, and pending litigations in various courts, and uncertain cash flows, and market volatility is there. So if at all these things are there, asset valuation or valuation of the company will deteriorate, and fraudulent transaction. If at all fraudulent transactions are more, definitely it is a problem. These require professional judgment and robust documentation by the resolution profession. And now technology in asset valuation. Today, the valuers are also, they are using the various methods, the conventional methods than the latest methods. Modern valuation increasingly relies upon AI tools. Once the AI tools is used, accurate evaluation will happen. Machine learning, yeah. Today, in my personal opinion, the IRP should have the AI, artificial intelligence, ML, machine learning, API, application program interface, blockchain technology, and the cloud computing. If these five are masterized, definitely some good results will happen in their profession. And GIS mapping. So mapping of the assets, where it is. So the particularly Google mapping type, we will drone inspections and satellite imaginary and digital twins, data analytics and blockchain records and ERP systems, all are to be used in technology, to be used in asset evaluation. Technology enhances the accuracy. Once you are adopted the technology tools in valuation process by the valuer who are having these basics, particularly some companies, it requires also, and speed and transparency. Suppose the one textile industry is there. or one car industry is there, or some pharma company is there. They are using the AI technology in manufacturing or production process. But if that AI value is properly identified by the valuer, definitely the company valuation will increase. If at all the valuer is not having the knowledge ABC of AI or ML or cloud computing or that particular blockchain technology, that data is preserved on the blockchain technology, and he is not having how to value the customer base of the company, then valuation will deteriorate. Valuation, correct valuation, realistic valuation will not happen. And the technology enhances speed and accuracy and transparency also. Case illustration, consider the steel manufacturing company admitted CIR. Book value of the asset is 900 crores, liquidation 620, fair value is 860. Expected enterprise value is the 1,350. So the enterprise value is very, very important. Company as a whole, that too going concern. If you take the book value always less. It is not a market value. It is a depreciated value. Suppose you take, for example, building is there. The building on account of a wear and tear, the value will decrease. But land, constructed building thereon, the land will appreciate. The land will appreciate. So we are taking only depreciation as per the income tax rules. And the real value is much more. That's why I told even in State Bank of India, my corporate that is located in Navi, Mumbai, the book value is 1 rupee. But 300, 400 crores, they will get it if at all. Nariman Point, Madam Kama Road, the location and the construction and the style and whatever the 20 floors building is there next to the Shipping Corporation of India, then nearby the LIC of India, the value is 300 crores. But in the books, it is mentioned as 1 rupee only. That's why I told in the starting point also, once the companies are, the balance sheet is a balance. 100 crores assets, 100 crores liabilities. Once the assets are given to the prospective resolution applicant for 100 crores, all liabilities, they will have liability holders, they will get the amount. Even equity shareholders also. Why? Because whatever the assets that are mentioned in the balance sheet, that is the book value, not the real value or the market value. But liabilities, exact value. Exact value. So that is 1,350 enterprise. Through proper marketing, transparency in bidding, and continuity of operations, 3 resolution applicants submitted 1,100, 1,420, or COC approved the highest competitive 1,420. So here, the valuation, beyond valuation, some of the companies, if you take the valuation, that valuation, the fair value is only 860. But whereas the bidding process of 1,420. So here, whatever the valuation, beyond valuation, you think it of. I told one building is the one land is there. The land latest registration value in that particular survey number is X price. But the land which is required for the industry, for the nearby, the water is available, nearby the labor is available, nearby the raw material is available, then it is doubled or tripled than the registration value. Why? Because for that industry, water is required and the labor is required, the nearest raw material is required, or nearest selling points, if all are there, not only the registration value, the beyond registration value. 3 or 4 times. Compared with the liquidation, stakeholders realize an additional 800 crores. Employees retain their jobs. Suppliers continue to the relationship. And the creditors achieve significantly high requests. Sir, 50% of the cases, no assets are there, the company is not working condition, and where the building, where the office, nobody knows, books are not available. But 50% cases, or at least 40% cases, this logic is useful. Employees retain the employees, don't discourage them. This is under CARP. When it will close, we don't know. And once the prospective applicant, they will take you or not. If that rumors are spread in the office, nobody will be there. Encourage the people. If at all we are the management, as on date, I'm handling the company. In the tomorrow, the prospective resolution, who is an experience in the line of activity, he will do whatever the experienced people, he may give higher amount also. Think it of before leaving the company. That's why today 120 candidates of ISRO, they are ready to resign. The scientists, the government is now immediately take a step. Why they are resigning? What is the reason? Don't accept their resignations. If at all any issues are there, they are ready to resolve. Employees retain their jobs, supplies will continue, and creditors achieve significantly higher recoveries. This illustrates that preserving the corporate data as a going concern and adopting a robust value process can substantially maximize their value under IBC. Value under IBC. Judicial perspective also. Particularly courts are also telling from time to time, value maximization, value maximization. Once you are thoroughly examined the value maximization, some good results will happen. That's why involvement of RP is also very much required. Indian courts are consistently emphasized the objective of IBC is a resolution in preference to liquidation and maximization of value of the corporate data asset. That is required. The commercial wisdom of the committee of creditors exercised on the basis of a reliable value and the transparent resolution process has been accorded significant deference by the judiciary and provided process compliance with the provisions of the code and applicable. Reliable valuation, that is required, not simply the valuation. If the company is not, a similar company is not there, the same type of company, monopoly, only one company in the market. Whatever the valuation, that is only the base. Beyond that, lot of higher valuation will happen. Only one company, the demand for the product is 100% and the supply is 0 or negligible 10% or 20%. The capacity utilization of the company is only 20%, 100% they can achieve. In that case, the resolution professional informed the COC. This company is a monopoly company. This type of company is not there in India. And a lot of demand is there for the products. The market, we are providing only 20% of the demand of the market. Remaining 80% is there. And we are utilizing the machinery only 20% or 10%. Remaining 90% of production should happen. Then whatever the valuation is there, beyond valuation, all these things are useful. And even equity shareholders, whatever the present market value of the company, they will get it if at all the distribution is happening. The last person, not only the waterfall mechanism, not only in the particular the liquidation, but also resolution plan, also the waterfall mechanism, if at all that is drawn, and definitely equity shareholders will also get. Once the company is handed over to the prospective resolution plan, whatever the value is finalized, the value, it is as good as the sale of the company. The jurisprudence developed by the Supreme Court and NCLATs underscore the preservation of the company corporate data is as a going concern ordinarily yields a superior value for creditors and other stakeholders than piecemeal recordation. Piecemeal recordation means death of the company. If at all the assets are bifurcated, one land separate, plant and machinery separate, building separate, stock separate, patent separate, then piecemeal reduces the valuation. Not only reduces, the company will disappear from the ROC website also. It is as good as a death of the company. Best practices in value maximization. The following practices significantly enhances the value realization under the IBC. Appoint experienced and independent registered valuers promptly. Don't compromise. Don't recruit known people or friends or who are recommended. Independently, you verify, you evaluate the persons. Ensure complete and accurate financials. Whatever the financials of the company is there, whatever the assets are there, all assets, you have to give a list of assets. Whether all these assets are reflected in the valuation report or not, legal, operational data is available for valuation. If at all you have given partial information, the accuracy will not happen. Preserve the corporate data as a going concern throughout the CIR. Try to even the valuer also, if the machinery is down and no production, even valuer also will reduce the price. If the machinery is running and wheel of the machinery is moving, then value will appreciate and recognize the appropriately value tangible, intangible, and digital assets. And that also to be brought to the notice of the some of the values, they are not that much competent in tangible and intangible and digital assets. Once the company is having the intangible assets and digital assets, first check in their resume and other things and prepare comprehensive, accurate, and investor-friendly information. Once you are filled up like this, definitely the valuation maximization will happen. Conduct a transparent and a competitive bidding and to attract a wider pool of the resolution. Competitive bidding, legal disputes, title defects, and operational issues at the earliest opportunity. Address the legal issues. Suppose the legal issues are there. If legal issues be during that one, if at all you address, then value will increase. People are ready to purchase. If at all any disputes are there, and resolve that one. And use of technology-driven tools, valuation, and robust data analytics wherever appropriate. So AI tools, definitely 100%. Because I'm also using the AI, particularly for various activities. The exemplary or extraordinary or whatever the big words are there. AI is only if at all people in the country are using, then lot of developments will happen. Even in my bank, check processing is scanned by the system. Once scanned, the amount, the words and figures, the signature, the check number, the IFSC code capture, and automatically the check will be posted in the concerned account. No data entry, no human intervention. If it are not matching, check will be rejected by the system. So that's why the AI tools good advantages are there. And the values focus on long-term enterprise value rather than only liquidation process. Hence, asset valuation is a cornerstone of the value management under IBC 2016. A sound valuation framework enables the resolution profession to present an accurate picture of the CD. Assist a committee of creators in exercising the informed commercial judgment, encourage the resolution applicant to submit a realistic and a competitive resolution. That is possible. That is possible by combining the professional valuation standards, transparent processes, preservation of the corporate data going concern, effective stakeholders coordination. That is also required in valuation. Simply, corporate data, he is not having voting right. He can participate in that. Sometimes you have to interact with the corporate data. Interaction means some the good information we can elicit from the corporate data. The insolvency ecosystem can maximize the recoveries. That is the preamble. That is the objective of IBC. Strengthen the confidence of the creditors confidence to be increased, and preserve the economic value and contribute to more resilient credit market. Once the creditors, financial creditors are not getting their stake in the IBC process, and if at all they have given 100 crores loan and they are getting only 20, in future they don't give any loan. If operational creditor are provided raw material and during the insolvency they are not getting, in future the companies will not get any credit from operational creditor. The success of IBC ultimately depends not only the timely resolution, but also ability to unlock the full economic potential discussed in enterprise for the benefit of all stakeholders. That is the objective. That is the preamble of the IBC. Now I will discuss about some critical areas to be verified by the resolution profession for maximization of the value of the CD through asset valuation under IBC. Sir, are you getting my point what I am telling from 3 o'clock onwards? Sir, madam. Hello. Am I audible, sir? Hello. Any doubts are there, sir? Any doubts, any clarifications up to this point of time? If there is no doubts, I will continue further. Okay. Now coming to what are the critical areas? One of the most significant responsibility of the resolution professional under IBC to ensure valuation of the corporate data. It should be complete valuation up to lost rupee, up to lost asset, up to lost liabilities, and accurate and transparent and capable of maximizing value. Although the actual valuation is carried out by the IBBI registered valuers, the RP must ensure valuers receive complete information. Conduct adequate due diligence. You have to provide complete information. And they have to conduct adequate due diligence, inspect all assets, and consider every value enhancing the factor before the arriving the fair and liquidation. Before arriving this one, they have to arrive the fair and liquidation value. Comprehensive checklist I will provide for value maximization, for a verification framework under resolution profession. What are the areas? General verification of the resolution profession. So to increase the value maximization, certain checklist to be understood by the particular resolution profession. What are the appointment of registered valuers? Appointment of registered valuers. Verify two valuers been appointed according with the regulation 27 of the CAR. First, you identify two values, competent people, independent, and knowledge with the latest AI tools. Confirm both values and registered values with IBBA in the relevant asset classes. Whether these values are with IBBA panel is there. You go to that IBBA website also, verify their history. How many companies, even though their resume they might tell so many things, but what is mentioned in the IBBA website? Ensure there is no conflict of interest. He should not be a relative. He should not be a friend. He should not be a known person, independent and qualified and skill oriented. Verify their independent declaration. They have to give, I will maintain the confidentiality. I will follow whatever the best practices in valuation. Confirm their engagement with the prescribed timelines. Prescribed timelines. Otherwise, once delay is there, then it will be a problem. Review the scope of work and their valuation methodologies. And you have to review what is their scope and methodology, what methodology is using and agreed upon. And the availability of records. Availability of the records. So ensure the values receive complete information. Don't provide partial information. Once partial information is given, then they will give only to that extent only they will give, the full valuation will not happen. Audited financial statement, fixed assets register, title deeds, insurance policies, all these things you have to provide. Lease agreement, if at all some assets are given on lease, mortgage documents and ROC charge documents, all are to be provided to the valuers. Bank valuation reports. So the COC, you get the information from the bank, that also you provide, and previous valuation reports. Engineer reports, environmental reports, pending litigation records, inventory records, intellectual property documents, all are to be provided to the valuer for a correct and accurate valuation. Plant layout drawings, you have to provide. Factory licenses, you have to provide. GST records, you have to provide, and income tax records also, particularly whenever you are paying vendors, but the vendors, the whatever the TDS and other things, that also you have to provide. Or once you are acquiring any asset, whatever amount you have paid or a TDS deducted, that also. Land valuation, a critical verification points. What are that one? The RP should verify whether the valuer has examined the original sale deed or gift deed or conveyance deed. So whenever the land verification, these are to be verified. Registered lease deed, mutation records, revenue records are to be verified by the valuer, whether it is valued or not. Pattadar passbook, in case of agricultural lands, Pattadar passbook is there, and encumbrance certificate. Normally, the encumbrance certificate will be taken for 13 years. In certain cases, 30 years also. Approved layout, whatever the Gram Panchayati, whatever the municipal corporation for construction of that buildings or construction of the plant and machinery production department, etc. Conversion orders. Conversion orders means agriculture land to the particular this one, the normal lands, commercial purpose, and land use classification, and zoning regulations, and town planning permissions. Once the construction has happened, the municipal town planning department, they will give the permission. Development restrictions. If at all they have given a development, that restrictions are also there, and physical verification, and ensure the verification of actual site inspection. So the GPS coordinates and boundaries measurement, physical position, encroachment, rights away, road frontage, and accessibility, topography, flood risk or soil condition, environmental restriction. All these things are to be verified by the particular valuer or not. That is to be verified by the resolution. Market information, whether he is providing market information, valuation considered or not. Compared market transaction, guidance valuation, circle rate, recent sale transactions, and future development potential, highway connectivity, metro connectivity, industrial corridor location, or SEZ proximity, or smart city impact, or infrastructure projects, etc., etc. These factors are also to be taken into consideration while arriving the market value of the proposed site or land or building, etc. Building valuation, the RP should verify structural stability, age of the building, remaining useful life, construction quality, etc. That is to be verified by the RP. RCC, reinforced cement concrete condition, or roof condition of the particular building, or foundation, particularly whether good foundation was happened to that particular building or not, flooring, electrical systems, plumbing, or fire safety installation in case of a building evaluation. HVAC, heating, ventilation, and air condition systems are working perfectly or not. Lift installations, warehouse facilities, whether all are covered, if that building is having that features, loading decks, office infrastructure, green building certification. Once it is there, that is also to be verified. Occupancy certificate, completion certificate, all these things are to be verified. Plant and machinery valuation. This is generally the largest component in the manufacturing. The RP should ensure verification of technical verification, physical inspection, make, manufacture, year of manufacture, installation date, capacity, model number, all these things are to be verified. Serial number, particularly the plant and machinery, are remaining useful life, the planting machinery, maintenance history, and annual maintenance contracts, AMCs for the planting machinery, that is also to be verified by the valuer or not, that is to be ensured by the RP. Spare parts availability for the planting machinery, automation, level technology obsolescence, and production efficiency. All these things are to be verified by the valuer. That is to be cross-checked by the RP. Energy efficiency, that is to be verified by the valuer. That is to be cross-checked by the this one. Operational verification, working condition, idle machinery, under repair, cannibalized, unutilized equipment, dismantled machinery, imported machinery, local machinery, or calibration records, breakdown history, all these things are also to be provided to the particular valuer by valuation, and whether all these factors are to be taken into consideration by the valuer or not, and commercial verification, replacement cost, market value, the scrap value, salvage value, transportation cost, installation cost, dismantling expenses, import duty. All these things are included in that valuation or not. Inventory valuation. RP should verify raw materials, physical stock of verification. How many slow moving inventory is there? What is the obsolete inventory? What is the damaged inventory? Or expired material or quality deterioration? All these things are also to be verified by the RP with regard to inventory valuation and work in progress. In work in progress also, if goods are semi-finished and RP has to percentage of completion, he has to get the information from the production department and the cost incurred so far, raw material converted into work in progress, how much additional cost is incurred, future completion, still how much it costs to be they incurred for a completion into finished goods, recoverability. All these things are also to be verified or cross-checked by the RPs. Finished goods, verify marketability, whether these goods are marketable or not. What is the selling price? Is there any export potential for these goods or not? Shelf life, how many months we can preserve, or if at all going to damage shortly, we have to sell at the earliest. Customer orders, how many are pending? Inventory aging, that is also to be verified by the RP. Security valuation. With regard to security valuation, RP should verify the valuation. Shares, if at all the company invested in shares or mutual funds or government securities or bonds or debentures or preference shares or commercial paper or certificate of deposit or treasury bills or investment in subsidiaries or joint venture, that is also to be verified. Verify the market quotations, net asset value in case of mutual funds, liquidity, whether a secondary market is available or not, restrictions, and a lock-in period, fair value adjustment. All these things are also to be verified by the RP with regard to security valuation, receivables in valuation. RP should verify age-wise receivables. How many 30 days completed or 15 days completed or 60 days completed or 90 days completed or more than 360 days, recoverability, whether the debtors are available or not, what is the present location, whether it is a related or unrelated party, and a legal disputes of bad debts, etc. Related party balances, foreign receivables also, export incentives on receivables, insurance claims and receivables, etc., etc. All these things with regard to debtors, oblique account receivable, oblique book receivables, that is required. Intangible assets. The modern business derives from enormous value of the intangibles. RP should verify the valuation of brand of the company, the goodwill of the company, the trademarks valuation, the copyrights, if any, patents or software, if any, or ERP system, IT or customer database. All these things are also some value, like intangible assets. Distribution network, dealer network, that is also good value, particularly in cement companies. If at all the company is having a network of the throughout India and the dealers are there, that is a good value. The new person need not worry about whatever the existing distribution is there. In that existing distribution, he can sell out and franchise rights. And if the company has given particularly KFC or the different companies are there, they are giving always a franchise and a telecom licenses. and pharmaceutical licenses, banking licenses, insurance licenses, and environmental clearance. These intangible assets are also some value is there, particularly bank license. Some of the banks or insurance companies, they are taking the companies as outsourcing activities. Outsourcing activities. The outsourcing, suppose the cloud computing is there. Cloud computing, the cloud will get from the bank, the bank data is stored in the cloud. For that also, the cloud is having some, the bank has given some license to preserve their data in their cloud. That type of licenses, whether it is insurance or particularly digital payments, also number of licenses are there. That is also certain value. Intellectual property rights, that is also to be verified. The registration status, the renewable validity, remaining life, licensing income, royalty, particularly potential, pending litigation, and commercial utilization. All these things are there. Not only that one, digital assets are to be verified. The RP should verify the valuation of domain names, websites, mobile application, software source code, whatever the software the company purchased, the source code is value. The source code, they can sell it to the other company and certain value, ERP platforms, cloud infrastructure, and customer analytics and artificial intelligence algorithms also. The blockchain technology assets, the data centers, and cyber security systems. If the company is installed the cyber security systems, that is also value. These digital assets, lot of value is there, but these are not reflected in the particular balance sheet. Why? Because 100% provision, the depreciation to be provided in first year of its operations. Financial assets, bank balance, the RPA has to verify. The fixed assets, escrow account. Some banks, they will create escrow account. Whatever the sale process are there, that will be created, and the bank will give only the operational expenditure, remaining amount for the repayment of the loan. Margin money for bank guarantees. How much margin money they have given, and investment, intercorporate deposits, etc. Security deposits, loan recoverables, all these things are also to be they verified. Security interest verification, and what type of security that are given by the company to the lenders, particularly mortgage or hypothecation or pledge or assignment. Mortgage means whatever the buildings are there, normally the company will give mortgage to the banks. Hypothecation means mobile stocks. Pledge means the possession, assignment, pari-passu charges, exclusive charges, ROC filing, CERSI registration, etc., DRT proceedings, and SERFACI proceedings, etc., etc. All these things are to be verified by the RP. Environmental verification, particularly pollution control board approvals are there or not, and environmental clearance. The prospective resolution applicant need not get all these things because it is a company, running company, going concern. All these licenses will pass on to the prospective resolution applicant. For acquiring these licenses and all these things, the earlier CD has incurred lot. Still some value is there. Environmental creation, hazardous waste management practices, contaminated land, environmental liabilities, and ESG compliance, carbon credit. Once all these things are in place, then value will increase. If ESG compliance is there, value will increase. Once the carbon credits are to minimize carbon emissions, particularly through air, the company is reducing with the latest equipment, then he will get the carbon credits also. Legal due diligence, pending court cases and arbitration. How many pending court are there? Once these pending courts are clear, the valuation will increase. Or if nil pending court cases, the valuation will increase. NCLT, NCLET matters, appeals, and tax disputes and labor disputes through labor code and etc. Land acquisitions issues, municipal litigations, all these things, if at all resolved, the valuation of the properties of the company will increase. Otherwise, the valuation of the company will deteriorate. Not only that one, insurance verification. And the company already taken insurance policies for 1 year or some buildings, even 10 years also. 10 years insurance policy. For a housing, even in SBI General, the insurance, they are giving 15 years policy. 15 years policy. Fire insurance or machinery breakdown insurance or marine insurance or loss of profit insurance or fidelity. If a loss of a profit insurance is there, if at all any claims are eligible for the company, then the RP should claim that amount. Fidelity and secrecy, guarantee insurance, industrial all risk policy. Then if at all any workman compensation claims are pending and supported by the insurance policy, then the claim to be appropriated to that the workman compensation. Thereby the burden or liability will decrease. Claim history, pending insurance claims, all these things are to be verified by the RP. And going concern value, the existing customer, the order book, the supply chain, the vendor network, the employee strength, the technical manpower, the business continuity, the production capacity, the market share, the future profitability. So once the going concern, the RP should ensure the valuers assess. Once it is a going concern, the value will increase. So once the existing customers are retained, value will increase. Order books are more, orders are more, value will increase. Supply chain system is existing, value of the company will increase. Vendor network is more, value will increase. Employees are retained by the company, value of the company will increase. Technical manpower is continued in the company, even though the company is facing CARP and going concern. Technical power value will increase. Business continuity is there, value will increase. Production capacity is increasing, value will increase. Market share, value will increase. Future profit. So, going concern value is much more than the others. And industrial analysis also verify whether the values are considered the industrial growth, the demand forecast, competition, government policy, import-export trends, technology disruption, and capacity utilization, commodity price. All these things are also to be verified by the RP. And evaluation methodologies. How the valuer is adopting the valuation methods, that also you have to look into. Market approach or income approach or cost approach, whether he is adapting cost approach or comparable company multiplies or comparable transaction methods or replacement cost method or net present value method, net asset value method or capitalization method. Whatever the method, why he is adopting that method instead of other method, that is also to be appraised by the RP. The reasons for selecting or rejecting the particular methodology should be documented. So the method of the valuation also one of the important criteria. Cross verification by the resolution profession. Next, the resolution profession, bank valuation reports. You have to verify cross-checking. Independent engineers report and the value report cross verification. Insurance company, they are also valuing the asset before taking the issuing the insurance policy. That also income tax returns. That also, and the GST returns, audited financial statement, cost audit reports, fixed assets register, all these things are to be verified. Previous sale transactions, projected reports, techno-economic viability reports, that also to be verified with the valuation reports, forensic audit reports. If at all the company, bankers, they have done the forensic audit reports, That is also to be cross-checked with the assets. Any alienation or misappropriation of funds are there, and the red flags affecting maximization. Sometimes the red flags are also there. Thereby, it affects the value management. Undisclosed encumbrance. If at all the company is not disclosed, the encumbrance on the asset, valuer will give the valuation, but he is not mentioned the loan also. Then it is a red flag. Missing title deeds. So for valuation, title deeds are very important. If title deeds are not there, what is the purpose of valuation? Suppose one building is there, the building title deeds are not available. But if at all you are allocated that the building to the valuer, what is the purpose of valuation? Unregistered charges. Sometimes, if at all you have not charged under ROC or CERSI, then the valuation impact will be there. Encroachment of lands. Once the company is encroached in other lands and the litigations are there, valuation, maximization will not happen. Obsolete or non-functional machinery. If a machinery is there, in the assets registry it is there. Today that is obsolete. No value. Idle or abandoned assets. Inflated book values. Book values are to be inflated by the companies. That is called window dressing. In that case also, it disturbs the valuation. Not supported by the market evidence. Understand the values due to the inadequate inspection. Understated values. Understated values. Sometimes the value is understated by the particular valuer. Inadequate inspection. And the omission of intangible and digital assets. They are not taking into the valuation. Values are not taking that intangible as digital. Pending environmental and statutory liabilities are also they have not taken. Then the value will be deteriorated. Related party transaction affecting the asset ownership. And the asset pledged multiple times. One asset, they are pledged to different banks. Asset located outside the books of account. Some assets are there, but it is not reflected in the assets book. And the difference between physical verification and accounting records. So the physical verification of that a particular asset is less, but whereas the books are more, or accounting system is more. Incomplete insurance coverage for or unsecured assets. That is also one of the assets requiring urgent maintenance that could materially reduce the value. This is also another area. Practically, value maximization checklist for resolution. Before accepting the valuation reports, the RP should satisfy that every significant asset of the CD has been identified and valued. That is to be ensured. Physical inspections have been carried wherever required. So, RP should also verify the location of the assets. And then only he can direct or address the particular asset to the value. Legal ownership and verify whether the title deeds are available for the assets or not. If title deeds are not available, there is no fun in valuing the assets. Title deeds to sell the asset to other party or the prospective resolution applicant, then title deeds are also very important. Encumbrance, security, interest have been considered. Once the asset value depends upon what type of loans they have taken. That also to be mentioned. Both the tangible and intangible assets are appropriately valued. Both are to be valued appropriately. Resolution provision. Before accepting the resolution valuation reports, RP should satisfy going concern value, enterprise value has been assessed where relevant. And industry trends and future earnings potential have been factored into valuation. and methodologies are to be adopted, suitable, well documented in the valuation. Then only the valuation maximization, the resolution applicant, prospective resolution applicant will believe the valuation reports internally consistent, supported by evidence, and free from material omissions. Whatever the valuation that is valued by the valuer, should be crystal and clear. That is to be, if at all any verification is required by the prospective resolution applicant, that is crystal and clear. Any significant difference between two registered values examined where necessary, reconciled according to CARP framework. Why difference is there? More than 25%, definitely the valuation, third valuation is required. Hence, although the registered value responsible for determining the fair value and the liquidation value, the resolution professional plays a pivotal oversight role in ensuring that the valuation process is a comprehensive, transparent, and based on complete and reliable information. That is required. And by rigorously reviewing the legal ownership, physical condition, operational capability, market potential, financial letter, intellectual property, and digital assets and security interest, the RP can significantly improve the quality of the valuation and enhance the competition among the resolution. Once up to last rupee of the assets of the company properly valued, reasonable valuation, realistic valuation, then the value maximization will happen. For that, the financial management skills, the asset where the records where it is available, and if you go through the PPT, whatever the checklist I have provided, if you go through that one, definitely good results will happen in value maximization. A diligent verification ultimately support IBC core objective, that is maximization of the value and a going concern while balancing interest of all stakeholders. So diligent verification process. Okay, valuer is giving valuation report and he is taking his particular fees. That is not the end. And whatever the valuation report is there, whether he covered all the areas, if at all he is not covered and given the report without intangible assets, ask them to they value the intangible assets and market value. So many factors are there. Whether he is taken into consideration of the factors or not. If at all only the spiral bind book he has given and taken that last amount, total amount of the company, if that is mentioned in the information memorandum, that is not correct. The RP should also involve in the process. Involve means not technical. Whatever the general information I have mentioned here, whether all precautions are to be taken care by the valuer or not, that is to be ensured by the. That is important one. That is important one. With this, I'm concluding. Thank you very much for your kind and patient listening for the last 3 hours. And I wish you all the best. And if at all any doubts are there, kindly pass on that doubts. Any doubts, sir? Hello? Am I audible? If there is no doubts, and this is with regard to, if you keep this PPT and take the printout, then while verifying the valuation, once again go through this list. Definitely some good results will happen with regard to value maximization. So thank you very much, sirs, madam. And thank you to ICSI IAP for giving an opportunity to discuss about the value maximization of the corporate data through asset valuation. Thank you. Thank you and good night to all, sir.
Shall we conclude?
Madam,
Sorry.
if there is no doubts, I will close. Okay, madam?
Yes,
Hello.
sir, we conclude if there are no questions. Participants, if you have any question, then ask. Otherwise, we have to conclude the session. So, shall we conclude now?
Yes, madam.
Okay. Thank you very much, sir, for giving your valuable time and sharing your experience and thoughts about the topic, asset valuation and the IBC.
Thank you, madam. Thank you. Good night.
Good night, sir.
आपको अपनी फोटो तो रखनी चाहिए, ऐसे थोड़ी होता है चूड़े बन के बैठ जाओगे, ये कौन सा शौक है।